inclusion, my lord.
Inclusion.
Restoration.
Next week.
Your Lordship, may I be permitted to mention a matter? Item number 1 that is fixed at 2 p.m. Your Lordship, Mr. Shubhodip Sen is appearing. He is unable to attend court today because of some personal difficulty. I am praying that the matter may be adjourned and kept after a week or two. Your
Is
Lordship.
for which side?
Your Lordship, the petitioner.
Union of India. Oh. Let it be called. You be here. We don't know who is appearing for the other side. When it is called, you mention.
Your Lordship, I'll come back at 2 p.m.
Yes.
Number 3.
My Lordship.
My lord, I am appearing, my lord. My junior is here, my lord. I am not, am I audible? But I am not, I am unable
Lordship, in this-
video, my lord, so that, my lord, I can argue. My lord, my junior is there, 3 and 4. My lord, am I audible? Sushobhan Sengupta, my lord. 3 and 4, it is covered by the Supreme Court judgment. Stay is granted in favor of the, my lord, appellant. And stay is continuing. And hearing is scheduled to be held on certain date. My lord, my junior is there. Item number 3 and 4. I could not connect the video, my lord. Am I audible, my lord? I actually.
Who is his junior?
Me, my lord.
For the
Item
respondent.
number.
Where is your junior, sir?
Sanjay, my lord. My lord,
Lordship,
I
may
am
I hand
appearing,
over
my lord.
the order of the Supreme Court, my Lordship.
My lord, I am appearing, my lord, on behalf of the, my lord, appellant, my lord. I am making humble submission that this is, my lord, the appellant got an order of stay against the judgment of the Honorable Division Bench of our Honorable High Court, my lord, and stay is continuing, and the hearing is to be scheduled to be fixed on certain date. And my lord, I'm sorry, my lord, my junior is not right now, is not there. But my lord, I am taking the responsibility, my lord, that yes, my lord, I went to the Supreme Court and got an order in my favor. In my favor means that they are in favor of the appellant, and stay is continuing. And the other side has filed and they are rejoinder in the Supreme Court.
May I hand over the division bench order of this Honorable High Court, my Lordship?
Oh, what
And
is to
that
be
order
done?
was-
It is to
Sir, it has been the,
My
they
lord,
have
that
filed-
order has been stayed. Division bench order has been stayed,
which order has been stated, sir? That order,
The-
that order. You are saying which order? You are
the division bench order. My lord,
Huh?
the state preferred an SLP. My lord, appellant preferred an SLP. My lord, in certain, because there are 17 matters. Out of 17, 15 matters, my lord, and 17 matters appeared, but my lord, these 2 matters, my lord, are not, didn't appear at that point of time.
all
But my
right.
lord, the issues are same.
So then what happened in those 14 matters?
Where that, my lord, stay is enjoying, my lord, the state is enjoying the state of till date. My lord, they are aware of that. Because the other respondents, my lord, who are the appellants in, who are the, my lord, the respondents in the division bench.
What is
Division bench, my lord, they are aware of that order of the Honorable Apex Court.
So the thing is, around total 18 appeals were filed by the West Bengal Essential Commodities Supply Corporation Limited, challenging the order of the Honorable Single Judge, directing the corporation to regularize the service of the writ petitioners who initially appointed on contractual basis, with retrospective effect from the date of their initial engagement. Now, Lordship, out of 18 appeals, 16 appeals came up for consideration, and 16 appeals were allowed by the division bench. Now, challenging which we preferred SLP. All the writ petitioners, they were represented in the Honorable Apex Court. Honorable Apex Court passed an order directing the parties to maintain status quo. That order is subsisting till date.
So it has to be placed after the Apex Court.
Yes.
My Lordship, the appeal bench has dismissed the appeal, my Lordship. Our Honorable Division bench has
Yes.
dismissed
Dismiss the appeal
my
filed by the
Then-
corporation.
Lordship. Supreme appeal in the Supreme Court, my Lordship. Now it has been stayed and it's pending before the Honorable Supreme Court, my
So
Lordship.
it has to come after the.
Yes, yes, yes.
My Lordship, I am appearing for item number 3, my Lordship, for the respondent. My Lordship, item number
So they were
contact with the respondent, my lordship.
A common
Runner 5.
Obvious manner.
noun appears on behalf of
Runner 6.
There is none to represent the parties.
And 7.
Lordship, item number 7, Mr. Kolal Bashu is on the petition, Your Lordship. I am praying for only not today, Your Lordship. He is engaged in quotum number 11, Lordship. I am praying for.
What to do?
Number 8.
Lordship, item number 8 and 9, I am informed by the clerk of the advocate appearing on behalf of the appellant that he is not well and he is unable to attend the court this week. I am praying for not this week, Lordship.
You are for?
Lordship, I am not engaged in the matter. I am praying for an
Appellant in 1124.
Yes, yes.
Learned advocate for.
Serve all the purpose.
Yes.
Number 10.
Lordship, in this item, I am for the petitioner. I am praying for short passover.
Third.
Lordship,
But the only thing is that this is a change brief, my lord. The copy of the writ petition has to be appended, my lord. I not find that copy is annexed, my lord. Whether it is annexed with my lord's copy. So the copy of the writ petition, my lord, need to be brought on record. It is whether it is part of it or not, which I don't know. Writ petition has to be brought. The bill was filed, then got there. Will take you lot to the 31.
Hardly any issue. Tell us what is the infirmity. You say UID was not mentioned.
Correct.
UID was not mentioned.
Yes. But
How does that cause any prejudice? That is the only thing.
the only thing is that it's causing the hampering the transparency. Why I'm saying so, my lord? My lord, it's a technology which was adopted, my lord. So it's a technology which was used, and there was this ID which was there to give the identity, specific identity. If your lordship kindly come to the order dated 13 May 2022, and I'll take your lordship to some of the portions to be clear. The petitioners say that pursuant to an
Order of?
order dated 13/5/2022, the order impugned. Here, kindly come to 7th line. The petitioners say that after completion of the selection process, the result has been published.
What is the date of the order?
Madam, 13th May 2022.
22.
Lordship will find it in my memorandum of appeal. In certified copy. You kindly come to 7th line. The petitioners say that after completion of the selection process, the result has been published without giving the identification number, but only referring to the Aadhaar number of the successful candidates. So this is the element which has given rise of certain suspicion in the mind of the applicants regarding the process, that why they would change it.
Paragraph?
Lordship, kindly come to the first paragraph only, 7th line onwards. The petitioners say
Yes.
that after completion of the selection process, the result has been published without giving the identification number, but only referring to the Aadhaar number of the successful candidates. So far, while the Aadhaar number is concerned, this is identifiable by the Aadhaar number, and identification number was created by them. Now, Lordship, kindly come to this. The petitioners say that by the process, Weibull Technology Limited has acted in a transparent manner. No, since the result have been published by indicating the Aadhaar number, it cannot be ascertained whether the person selected had actually applied for the selection process, because it is a technology generated number. Now, actually applied in the selection process and got selected, or the selected candidates are from outside the applicants. If the result was published against the identification numbers given to each of the applicant, it would have been easier to know which of the applicants have actually been selected. The petitioners say that confusing reports are being circulated through social media and apprehend the scam. The petitioners therefore internally are seeking a direction to allow them to join the data entry operator at Bangla Shoyata Kendra. On behalf of the Weibull, respondent number 2 it is submitted, they were entrusted the job of selecting the candidates. The procedure followed by them is absolutely transparent. In order to identify the applicants, the respondent number 2 had provided the identification number. So they themselves say they have provided in order to identify the candidates. After completion of the selection process, the respondent number 2 has submitted the final list to the selected candidates to respondent number 1, who has published the result. So, Lordship, they have prepared the result and sent it to respondent number 1, and who had published the result ultimately. It has never within the domain of respondent number 2 to publish the result. Under the selection process, the respondent number 1, according to the respondent number 2, found in convenient to publish the result by indicating an Aadhaar number of the selected candidate instead of giving identification number by respondent number 2, as the respective other numbers were available along with the online application. This cannot be any manner alleged
Where
to
is
be
the result? We have seen it. Where is the result? Where is the result?
Those results, my lord, are next.
So your whole case is that since a unique identification number was granted at the time of submission of
Yes.
application, the result was required to contain the identification of the candidates with reference to the UID.
UID.
Yes. So where is the
So,
result?
my lord, that is required to be brought. My lord, unfortunately, that petition is not annexed in my copy. Well, it's a change.
No, it must be here. There are so many affidavits and supplementary affidavits and reports filed. It is here.
My lord, it
They
was
have been
not-
directed to file the report, and the report has been filed.
my lord,
If
re-
every day a learned advocate
kindly,
changes, we cannot
grant me
keep
some
at
time.
learning the
I'll bring this by way of supplementary.
No, it is here, sir. We'll show you where it is.
Read
It is
petition.
part of the brief.
If the writ petition is there, I'm ready, my lord.
No. Where is the question? This is the result is right here. We are showing you.
Results are annexed, my lord, in the writ.
Yes, because this court in this proceeding has already directed them to place it all on record. It has been placed. So therefore, you proceed with that.
But those reports, my lord,
The report was filed, exception filed, everything done.
all this.
So report refer to
If
that.
your lordship, I will refer. So that is my case. Now, lordship, kindly come to the one
So
reply.
in fact, your whole writ petition is founded on an apprehension. You say that because this UID is not mentioned in the list, there is a scope that somebody who has not participated may have been included in the list. That
My
is your case.
In the writ petition, my lord, I have taken some of the awardments. May I read it from the writ petitions, my lord? So far, this apprehension part is concerned, my lord. My lord, from paragraph Roman 6 onwards, being surprised and confused with the said details of the new engagement of data entry operators viral in the social media network since the petitioner's appellant number 1 made an application under section 6(1) of the Right to Information Act 2005 before the concerned public information officer, HON'BLE Technology Limited, Block EP such and such, asking the information whether any list of engagement was published or not, and details of the new engagement viral in the social networking site are genuine or not. The said application was served on such and such date, but till today, after expiry of more than 2 months, no response was received. That the detail of the new engagement of the data entry operator for Bangla Shoyata Kendra in several districts are confusive and questionable, as the said publication was not come up from the authorized portal of the HON'BLE Technology Limited. Despite that, in the details of new engagement, it is found that the name of DO has been serially written with their Aadhaar number. It is surprising to see that where applicants are called on the interview with their application ID, but in the details of the new engagement under the questions, the name of the DO has been written with their Aadhaar number. That the details of the new engagement of data entry operators must be transparent and maintain transparency in details of engagement data entry operator must be contained with the selected names of DO with their application ID. It cannot be distinguished to any selected applicants whether they appeared in the process of interview or not. The reasonable suspicions of the petitioners cropped up in their mind by the Aadhaar number. The applicants who may not be appeared in the interview are the placed the selection list published by the unauthorized social network in viral public. Now here, my lord, we have given certain documents where the results were given. And before I take your lordship to that, I will come to some of the, suppose one of the admit card, acknowledgement receipt. Here also lordship will find that date of birth, gender, application for the, apply for the post, mobile number, email ID, application number which was generated, and Aadhaar number. Now suddenly this application number was replaced by the Aadhaar number at the time of publication of the result. Now
So omission to mention a UID leaves a scope for you to apprehend that those who have not participated, they may have been declared as selected candidate. And this assertion you are making because there is something going viral on the social network. And on that basis, the red court should have directed for
inquiry. It should have
inquiry.
that what why they should now lordship kindly come.
Where is the prayer in your writ petition? What was the prayer? Please
Right.
read your prayer.
My lord, the stay during the pendency of the appeal for restraining the respondent authority from taking any action relating to the recruitment of the engagement of data entry operators in different districts for the ends of justice and stay operation of the form of restraining order as said above necessary till the adjudication of the said appeal. Directing enforcement of the fundamental rights such and such as the data entry neutral, impartial investigating agency should investigate.
That's all.
That's all. Now the question is kindly come to their reply once.
See their report.
Yes, reply. I'll come to their reply.
They have filed a report pursuant to this court's order.
Yes, my lord. Who has
And
filed
that
the
report
report?
was
HON'BLE has filed.
accepted. Huh?
HON'BLE has filed the report.
Yes.
It's not the person responsible to publish. HON'BLE categorically said that we have not published.
Yes,
They
we
said
have
they have
seen that.
prepared.
They said we have prepared the list, we have forwarded to the state.
Now
State has
state has decided.
published, not decided, published.
Published.
Yes.
And HON'BLE said that we have prepared by the UI.
Maybe,
The state-
maybe, yes.
Now that means the
Will that give rise, will that give rise to a tangible apprehension so as to proceed to direct for an inquiry by an independent agency?
If I'm asked,
That is the question which we have to consider. We have understood the facts. Applications were invited. At that time, they were given a UID. that UID was for the purpose of identification of the candidate. At the time of publication of result, they have published the result with reference to Aadhaar number. You say why UID was not
Why
published?
this was replaced?
Now they say UID was granted for processing the application and the candidature within the organization for identification purpose. That has ceased to have its significance once the recruitment process is over. There is no better identification of an individual than an Aadhaar. So we have published the result giving the person's Aadhaar number.
They did not
This is
say
the
so, my lord.
oh, they have said so, sir.
But on the affidavit, they have not.
They have on affidavit said so.
It's affidavit, lordship. It's affidavit filed by respondent number 2.
Yes, they have conducted.
Payable.
They are the only persons who can say what
They
has
have
happened.
not changed. It is changed by the
No, they have done the entire recruitment process. They have sent the result.
but result was published.
So therefore, that
published by
only
this-
that is being made a basis for you to have an apprehension in your mind, and based on some social, some viral,
So I made a
something viral on
complaint. I
the
made a complaint to that.
and on that basis, the writ court should have directed
Directed
for
for
inquiry by an independent agency.
Investigation, because that why my question is made. Kindly come to their reply once. Reply by the appellants to the last served by the respondent number 2 as per the directions of the order dated 15/5/2023. This is the reply by one Dibyendu Chakraborty.
Hmm?
One Dibyendu Chakraborty.
Just let us find it.
It is our reply, Lordship. Kindly come. Respondent number 3. Kindly come to their affidavit report in the form of affidavit filed. Before I go to respondent number 3 reply, first I would like to refer to report filed in the form of affidavit by respondent number 1. Well, this was by the department. Kindly come how they have dealt with it. Well, paragraph number 4.
Please just give us 1 minute. Let us.
Well. Page 10, madam. The state's report I'm referring. Report filed in the form of affidavit.
Yes, we have got it.
Well, kindly come to this report once, madam.
It is of which date?
Report
3rd May 23.
madam, 3rd May 23. But in page 10, my lord, it's the report they have referred to this. But kindly come. The report thus prepared and placed as below for the consideration. The appellant filed the instant writ petition challenging engagement procedure of the data entry operators for PSK conducted by the HON'BLE Technology Limited. WTL was assigned by the state of West Bengal to conduct the engagement procedure for the data entry operators for PSKs. That the candidates were asked to apply in the online portal of the official website created by the HON'BLE Technology Limited. That the petitioners applied in online mode by uploading the documents in the online portal of WTL, and suitable provisions were made for inviting applications from the applicants for engagement of the post of DEO. That the eligibility criteria for the engagement of DEO were notified as HS pass within the age limit of such and such. Now, 6, the WTL received 68,703 applications online, and after scrutiny, 60,910 number of candidates were shortlisted for interview. An unique application ID number was created against each registered applicant on the said online portal for the convenience of the WTL for selection procedure of the candidates. The said unique application ID number was in addition to the Aadhaar card number. Now, kindly emphasize here addition with the Aadhaar number and other requisite information which each and every applicant had provided in their applications. The details of the particulars are as follows. Now, here they have. Yes. Well, here, if you want to kindly take note of this, that the said unique application ID number was in addition to the Aadhaar number. I say this was not in addition to the Aadhaar number. Now, when government engage any of the agency to conduct the preparation of the result, it may assign the duty.
Where have you said in your exception that it was not in addition to the Aadhaar number? Show us from your exception. This is not your case, sir. You do not deny or dispute that Aadhaar and UID were both taken. You say why UID has not been given in the result. That is all.
Yes, that was not been answered by them. That
They have said so. You say that it was not in addition. You have submitted, but that's not your case. You cannot show from any government that Aadhaar was not taken at the time of application. Aadhaar was taken right from the date of application and it has continued throughout the process, and the result contains the Aadhaar number.
but not for the purpose of preparation of the result.
No, so therefore, your only grievance is that something has come in the social media from which it appears that UID was excluded in the result to bring in persons who had not participated in the
Kindly come to
recruitment.
my exception once minute. Paragraph number 6 of my exception.
Yes. Show us.
Paragraph number 6, madam.
Yes.
With reference to the report in connection with CAN number 1 of 2022 arising out MAT number 905 of 2022 as annexed and marked annexure R3 in page number 9 to 12 of the report in form of the affidavit filed on behalf of the respondent number 1. In the said report, there are 10 paragraphs. From the paragraph number 1 to 7, only the criteria regarding the recruitment procedure of the data entry operators for BSK has been stated. And in respect of paragraph 8, 9, and 10, it is stated by bold marking a sentence that one of the important supporting documents for the verification of identity of the candidates was Aadhaar card. It is admittedly stated that a unique application ID number was created by the respondent number 2 for registering the candidates in the online application portal and for the accurate identification of the candidates. The Aadhaar number was used because the Aadhaar card is the best possible identity document, and in the acknowledgement slip issued to the various candidates contains both the application ID
Exactly.
and
So
Aadhaar number.
the acknowledgement of application contains both Aadhaar and UID. So UID is in addition. Your case is not that UID is not in addition.
Now, card number along with the other particulars
Correct.
already mentioned.
Correct.
In acknowledgement of the unique. That
Yes.
is, in
Now
acknowledgement
we'll
of
show
the
you
unique
where is the acknowledgement. Just have a look at the acknowledgement. It is R/3 of the other report filed by respondent number 2 in April. Prior to this,
Well,
come to R/3 of the report filed by on behalf of respondent number 2. Prior to this, they have enclosed a copy of the acknowledgement slip. It shows that Aadhaar number and UID is both there. It's not your case that is not in addition. That is your case. But you say why it is not there in the result. Your whole grievance is why it is missing in the result.
I write it here.
There's nothing else.
So I'll kindly come.
And that also you are actuated, or you have come to believe that there is something wrong going on because you have come across something on the social media. It is going viral. And on that basis, you want the writ court to direct for independent inquiry by an independent organization.
This replacement, kindly see, the Aadhaar card number may be the best possible identity document for the person.
No, that's not the point. The point is Aadhaar is there right from day one.
Yes, but it was
So
there for
therefore,
the purpose
UID
of the
once.
acknowledgement, but not for the purpose of the preparation of the
How
result.
many times you will say that? You have already said that 3-4 times. The point is there is an identification number right from the date of application till the date of result, which is consistent. Now, one other report or number comes in between, which is now missing. How will that affect anything? From the date of application till result, the Aadhaar number is there. So if you want to find out whether this person had applied or not, you can still do it. UID is not required. It is not that earlier Aadhaar was not used, only UID was used, and subsequently result has been published by Aadhaar.
Earlier, Aadhaar was
That is that's not your case.
My case is after their report is published, the agency say that we have never used Aadhaar.
Forget about
That is
it.
their
What they
categorical
say
stand.
is hardly relevant. Is there any occasion for the court to direct or come to a conclusion that there is something worth inquiring into? That is all we have to see. What respondent number 1 says, I have not published, 2 has published, that's hardly relevant. The point is, where is the occasion for the court or the writ court to come to a conclusion that yes, look, something is wrong, we have to direct
Well, may
an
say,
inquiry. We don't find.
May I say-
That's not your case. It's not your case that UID was not in addition. UID was in addition. It is admitted fact. Aadhaar was there right from the date you made your
Yes, with
application.
the recruiting authority.
So
But
that's all. Anything else?
get assigned this thing.
Anything else?
May sum up.
Yes.
I will read this and then I will sum up.
Yes.
The Aadhaar card number, I have also taken this stand. The person cannot be identified whether he or she is registered as a candidate in the online application portal or not. This identification is only distinguished by the unique application ID number. Hence, the report filed by the behalf of the respondent number 1 cannot clarify the reason for publishing the final list of the selected candidates by their Aadhaar number instead of unique application number. This is completely intransparency from the respondent number 1. So, my lord, I raised a question in the opposition also. My lord, third and last thing which I want to submit to your lordship that
It is for recruitment of data entry operators
data entry
on contract basis.
contract basis. Now, what has happened, my lord, here, it's a recruitment process which starts with the advertisement and ends with the selection. And it has various components. The first thing is that who conducts the recruitment examination?
That's not an issue
The
here.
agency.
That is not an issue
Agency
here.
categorically said, and it is
See,
recorded in the order.
you are arguing things which are not an issue. Your only issue is absence of UID. You don't say anything else. Apart from this, see, till the date of declaration of result, you found no infirmity in the process because you very well participated without any objection. Only when the result was declared, when you saw that UID was omitted, you said why this has been done. So prior to that, nothing is raised, nor can it be raised.
The last thing which I want to submit, that this stand taken by Weibull, it is submitted, they were entrusted to job selecting candidates. The procedure followed by them is absolutely transparent. In order to identify applicants, the respondent number 2 had provided identification number. So Weibull had provided. Thereafter, the government, while recruiting, they changed it and they came to Aadhaar. So they access to this Weibull identification number. They came to know what was the purpose, why this UID was given, for the purpose of keeping the identity of a person. Because the acknowledgement was not expected to be there with the agency, recruitment agency. So that has created my suspicion. And my lord, my letter also, which was addressed to the concerned public information officer, I wanted the informations which were not given. And this is my case, my lord, I cannot develop it.
Heard the learned advocate for the Number 11.
But I'm for the appellant. It's fine. Copy. My lord, I would be praying for a short, not a short 2 months adjournment, my lord. This is under active consideration by the present dispensation, my lord. I think it would be settled.
What is it?
This is a equal pay for equal work matter, my lord. It was rejected. So against that we have come. But presently it is being actively considered. So I'm praying for 2 months adjournment, my lord. I'll serve a copy of this to the learned advocate on the other side, my lord, because she's not having a copy also.
A submission is advanced. Number 12.
But I am for the appellant, my lord.
For the?
I'm for the appellant petition, my lord. But certain documents, certain documents which are very much vital for disposal, my lord, has not been annexed in the stay application. But I am praying for leave to file a supplementary ABDP to file.
Why, sir? They are documents from the writ proceeding, or they are documents
Those documents are
other than what was there before that?
yes.
No, then will not. Sir, you proceed.
Documents were supplied, my lord, after conclusion of trial.
Maybe. If that was not a material before the writ court,
But as per instruction of my senior, my lord, I am saying, my lord, sorry.
we will not allow you to introduce documents, because otherwise how the correctness of the judgment can be seen? It is based on the material before the Honorable Single Judge.
Kindly take it tomorrow, my lord, because
Yes.
senior asked
We'll
me
see whether there is any scope, then we may, just not for the asking.
very well.
Yes, not today.
My lord, I am appearing on behalf of the appellant, my lord. During the pendency of the appeal, my lord, respondent employee died, my lord. And my lord, the substitution application has been filed by the respondent without supplying us the copy, my lord. Anyhow, they have filed the substitution application. Another thing happened, my lord, so far my advocate on record is concerned, my lord, he also passed away. Therefore, fresh Bokalatnama is also required to file.
You are not filed yet.
Record হয়েছে?
The bank is the appellant.
Thank you, sir.
So you proceed, let us see.
In this matter, my lord, matter has been admitted, and thereafter, my lord, Chief Justice was pleased to direct us to file written notes of argument.
Yes.
My lord, that has not been prepared also, my lord. My lord,
Do we need a written note of, what is it arising out of a proceeding?
yes, my lord. Disciplinary
What happened? What is
proceeding
the,
was sanctioned without following the rules, my lord. Thereafter, disciplinary proceeding has been initiated, and learned single judge has held, my lord, only the plea, the charge at the time of issuance charge sheet.
no, what the inquiry officer has held is more important.
Yes,
What
inquiry
Honorable
officer
Single
held
Judge?
is guilty. Inquiry officer held is guilty, and thereafter
The inquiry report found the allegations to be proved.
Proved.
The allegation of sanctioning loans dehoes the rules or norms.
not following the rules. My lord.
Which rule? Where is that in the charge memo? Show us from the charge memo which rule was violated. Sanctioning of a loan is always a risky business.
Page
It is not mandatory that all the loans have to be recovered.
73 is the my lord,
Huh?
chart sheet. Chart sheet has page 73.
Page
73. did not scrutinize the search report in a proper manner, my lord.
Who did not scrutinize the search report?
Delinquent
Delinquent was posted as
manager, my lord.
manager.
While he was working as a manager at Deo, Khejuri branch, Deo Khejuri branch.
And it has been established with reference to which material? Who has deposed or which document was proved before the inquiry officer? We have seen it, all the loan disbursement vouchers were placed, but who has supported the allegations before the inquiry officer?
For the repetition or respondent. Well, repetition or respondent has died.
That has intimated.
I have filed an
Why you have not given a copy to him?
Yes, I have given a
Yes,
copy.
copy.
I have given a
Without
copy.
informing us, it is our carriage of proceeding. Therefore, we should file the substitution. Anyhow, my lord, they are filed, my lord. I have no objection. Lordship, allow it.
Yes, but what is the CAN application?
2026. I have served him a copy, my lord.
Yes, I've got it.
No, perhaps we heard wrong. We thought that you said that copy was not served.
Copy was served without informing us the details. Then we could file the substitution.
What happened? My learned senior friend's advocate record has
Yes,
passed
right.
away.
Also,
Died.
I informed the court. But
Learned
my
advocate
advocate
of my
record has,
learned
Yes,
died.
that unfortunate development, he has informed us.
That the decision is
therefore,
with whom
fresh
he can.
local of the is also required.
But you said now it is filed.
Not filed. But if the solicitor comes quick, therefore they till now not filed. They will file shortly.
So you have no power to appear today. Then why should we allow this substitution? You file your Vokalatnama.
Subject to correction, this application is within time. So it's required to be.
They are not represented. There is no power. How can we let them?
This application is required to go before the learned register lodgement for substitution.
For?
So substitution allowance of the application. Since it is within time.
Whatever it is, unless they file their power, how it can proceed, that we are seeing. We are informed by Mr. So-and-so learned. Records be sent down to the department. Matter is made returnable.
Now, 14, Your Lordship, in this matter, my learned senior is appearing on behalf of the appellant. 3 days back, he has undergone a surgery for which he is physically indisposed. I am humbly praying 2 weeks accommodation, Your Lordship.
Mr. So-and-so learned advocate.
Now, 15.
And pointed out from the stamp reporter, there is a delay of 8 days, my lord. We have prepared it, but it is sent to the bank, but the dealing officer is out of station, my lord. I require 1 week time, my lord.
As spread list after 1 week.
After 2 weeks, my lord. 1 week, my lord.
My lord, the respondent is, my lord, more than 75 years of age, my lord. He hasn't got any salary since 2012.
Give a date after 2 weeks. List of as paid list after 2 weeks at the top of.
Second.
Number 16.
Your Lordship, in this matter, my learned senior is appearing on behalf of
My lords, I am praying for a short pass over the learned advocate for the petitioner is engaged in courtroom number 25.
2 weeks accommodation, Your Lordship.
Same order as in the earlier case. There for adjournment on behalf of the respondent, not.
Number 17.
Your Lordship, I'm from the petitioner. The advocate and record is having health issue, praying for not today, Your Lordship.
Hmm?
Have a copy, Lordship, keep it after.
Or is a fresh case?
Yes, sir.
This is a fresh case, then you can download it. They must have given it on the server. Not today,
To oblige, Your Lordship.
no orders. Tomorrow.
Number 18.
Lordship, I am appearing on behalf of the appellants. I have served the copies to all the respondents in this matter. And I have filed one application under section 5. There is a delay of 708 days. In
708 days.
8 days, Your Lordship, because these applicants were not the writ petitioners before the Honorable Single Bench. They were added parties last year and the order was passed in 2024. Since the application was filed by these appellants, it was never heard by the Honorable Court, and for which the applicants have preferred this appeal before Your Lordship. Because regarding
Copy, because I'll have 708 days, I'll have to see.
we have served, but we will serve it again. This is regarding the selection process.
So why it has been filed after such a long time?
Your Lordship,
More than 2 years.
almost 2 years. In May 2025, they preferred the application of intervener before the Honorable Single Bench, Your Lordship.
For being impleaded.
Yes, Your Lordship.
Then
But that application has not been heard and that matter is assigned matter. We have mentioned it on many occasions, and the applicant of 9071 writ petition, in which the order was passed by the Honorable Justice Rajasekhar Mantha, it is regarding challenging the irregularities. They have not prayed for their selection, not for the publication of the result, just for the for addressing the irregularities of the
you
officials.
said you filed an application for impleadment. What happened on that application?
It has not been attended by the Honorable Court.
The matter is still pending.
Yes, Your Lordship. And the record is before the Honorable Chief Justice, Your Lordship, in the office. So I cannot provide the certified copy. A direction may be given so that it may be concluded, the application may be heard and the writ petition may be disposed of by the Honorable Single Bench. That has also been prayed in this application, Your Lordship. For setting aside of the interim order so that the result may be declared, because these applicants had not met with any irregularities in their centers. 9 centers has been mentioned, and a few centers had some problems for which the writ petitioner came before the Honorable Court. It was never mentioned by the writ petitioner.
You sought impleadment as a respondent.
I am impleaded as yes, Your Lordship. Pro forma respondent. To some extent, we
You are
were.
affected by some stay order.
Yes, Your Lordship.
What is that? Where is that stay order?
Yes, Your Lordship. The stay order is dated 24 April 2024, Your Lordship. It is at page 12 of Can 2, Your Lordship. May I read out, Your Lordship? Page 12. The petitioners are aggrieved by the examination conducted by the Public Service Commission for the post of Sub-Inspector in the subordinate Food and Supply Services, Grade 3 under the Food and Supply Department, Government of West Bengal. The advertisement is dated 22/8/2023 and the examination was held on 16th and 17th March 2024. When examination got over, the petitioners found that examination paper had been leaked and was available in various WhatsApp groups. Some candidates were seen writing answer scripts in open by referring the answers given on their mobile phone. Photographs of certain persons with answers written on their legs are also annexed to the writ petition. There are WhatsApp messages offering jobs against payment of money. The learned advocate for the PSC submits that pursuant to certain complaints received from certain quarters, the concerned district where examination was conducted were asked to submit reports on any allegation of impropriety. Some district reported certain malpractices in some area and about 60 FIRs have been registered. Further action is initiated by the PSC in this regard. Mr. Shamin, learned advocate for the petitioners, has filed a supplementary affidavit annexing some FIRs. The court is of prima facie view that the recruitment process cannot be allowed to proceed any further. This court therefore orders a stay of the recruitment process to the post of sub-inspectors in the subordinate Food and Supply Services Grade 3 under the Food and Supplies Department, Government of West Bengal, conducted pursuant to the advertisement dated so and so, published by the PSC. Given the number of FIRs across the state, this court is of the view that investigation in respect of these 60 odd FIRs and all other FIRs in respect of the recruitment process must be transferred to CID West Bengal. Let each the FIRs registered in report of the aforesaid recruitment process stand transferred to by investigation by each and every police station in the state to the CID West Bengal. The PSC shall publish this order on the website and also inform each officer in each district to communicate to the concerned police station to ensure compliance of the transfer of FIRs and case diaries to the officer of the CID West Bengal located in their district. The CID West Bengal may in its discretion form any team of their officers to investigate and submit a report before this court on the adjourned date. The report of PSC received from all districts and instructions of OC Taliganj Police Station as taken on record. Please the matter on 22nd May 2024 with WPA 10541. Now, Your Lordship, in these two
So on the date of passing of this order 23/4/24, your application for impleadment had been filed.
Yes. No, on that day it was not filed. Later on we filed, Your Lordship, when the case was not heard for a considerable period of time and no.
What is there to be heard? There are so many FIRs, more than 60
Yes,
FIRs.
Yes, Your
Unless all
Lordship.
that is completed or concluded, how anything can be considered?
Your Lordship, panel is still open. Few students have performed very well and they are sent.
Don't know why they have performed well is a different issue.
Retest may be conducted, Your Lordship. Some
How can be the FIR is there. You want us to quash the FIRs in a writ proceeding?
fresh examination,
So
Your
that
Lordship, for the posts which are
so
lying.
who said not to conduct a fresh
Yes,
appointment?
they are not conducting, Your
So
Lordship.
who said where is the order restraining them from conducting a fresh appointment recruitment process?
Your Lordship,
There is no such order.
Unless this matter is closed, Your Lordship, by the Honorable.
You don't know how you are saying so. There is a recruitment process. The petitioners complained to the court that we came out of the exam hall. We were told that the questions had leaked an hour before the exam. The questions were outside while we were writing the answers inside. Based on such allegation, there are more than 60 FIRs. In all the FIRs, the proceeding was going on. Now refer to CID, which is looking into it. In such a situation regarding the recruitment process in question, what order can be passed? You tell us. Can we say that you proceed with the result? Or can we say that so and so has performed very well, you publish his result? How can we say
Your
that, madam?
lordship, in the subsequent order, your lordship, the number of charge sheets and everything has been
Forget
mentioned.
about that. Where's the occasion for us to say anything at this moment? It has to be stayed in abeyance. How can it proceed further?
Your lordship, for the
What else is a strong
vacancies-
prima facie case, balance of convenience? Everything is there.
Yes, your lordship, but for the vacancies, your lordship, fresh recruitment process. can
Therefore,
be
we are saying
initiated.
that is another limb of your submission. Who is preventing them from proceeding afresh or for a new recruitment process? Nobody. It is for the state to decide when it will conduct a fresh recruitment process.
Your lordship, it is.
Can the court direct that you conduct a recruitment process?
Your lordship, we can be heard, your lordship, by the honorable single.
To what avail? Therefore, we are asking you. Either you are an accused in one of the criminal cases or you are not.
No, no, no.
Have you said anywhere that none of you are accused in the criminal cases? Where is that averment?
It is.
Where is that
averment in the
averment?
Can one, your lordship, can.
Please show that averment. There are 60 FIRs. Perhaps every center there would have been a.
Charge sheets have been filed, your lordship.
No, is there any averment in your IA that none of a charge sheet or we are not neither named in the FIR nor any charge sheet has been filed against
Charge
us?
sheet has been filed against few officials and few. I have paragraph 3, your lordship. Paragraph 3 of my CAN application, your lordship, page 5. That the appellants, may I read out, your lordship? The appellants are sincere students and they performed very satisfactorily in their written examination conducted by the PSC on 16th and 17th March 2024. They did not see any disruption in the examination center due to the malpractices of the, as alleged in the writ petition. There was complete peace in the said examination center. The petitioners were expecting their selection in the merit list, but due to the subsequent filing of the writ petition, 2 of whom participated in the same examination from Nodia, Shibpur, Howrah on March 16, 2024, the entire selection process was stayed by the Honorable High Court due to the complaints of large-scale malpractices wide order dated so and so. That the writ petitioners are the candidates who have filed the writ application for the impartial inquiry into the leakage of question papers and the answers in the selection process of the post of so and so. Now, paragraph 9, your lordship, that the panel is still continuing and the
Please read paragraph 8.
8.
Yes.
Yes, your lordship. That the writ petitioners have informed about mass scale leakage and annexed few WhatsApp messages which were not related to them in any manner. The investigating agency can arrest the concerned person to know the real facts. The petitioners have not prayed for the vacation of the stay so as to enable the completion of the recruitment process.
So therefore, if there is no prayer with reference to the recruitment process in question, for what you will be impleaded? When you make no prayer for the recruitment process in
This is
question.
not my writ petition, your lordship. The writ petition was filed by certain candidates who had not prayed for the for their selection. They have just prayed for looking into the irregularities of the selection process and to stay the proceedings.
That is about the writ petitioners, but then you say the petitioners have not prayed.
No. That writ petitioners have not prayed. In their writ petition 9071, your lordship. This is the question.
So therefore, we are asking you, is there an occasion to vacate the stay in these facts and circumstances?
Lordship, at least in the centers where there was no disturbance.
So therefore, we should conduct an investigation before the police.
Yes, your lordship. So
wonderful.
Conduct investigation.
So it is pending before the police. We should start an inquiry.
No, your lordship. A direction may be given so that the centers which remained unaffected by thus.
Who knows which centers were unaffected today?
Some reports are.
Who knows today? And who can decide that which center was unaffected? A large scale irregularity in the examination, question leaked, questions were being circulated through the WhatsApp and all that. How can we direct which center has remained unaffected?
All the 3 writ
Because this is a self-serving claim of the writ petitioners. We can appreciate that they are very sanguine that we have not done anything, but how can any court at this juncture come to a conclusion that these persons have not done anything and these persons have done something when the entire thing is being investigated in more than 60 FIRs? Which is the occasion?
Lordship, they have enclosed identical documents in all the 3 writ petitions.
Where
Your
is the
Lordship.
scope to go into this? That is all we are asking you. What is the scope of a writ proceeding? Tell us.
The panel may be closed, Your Lordship.
Huh?
Something, at least this existing panel for
Yes.
vacancy, which is subsisting till date, it may be re-advertised for
So tell us, shows the law that we can direct that the state should conduct a recruitment process because vacancies are there. Show us. See, these are issues for the state to decide when it wants to appoint, when it does not want to appoint.
But
We don't know what is the
suffer, Your Lordship. This unemployed students suffer, Your Lordship. Can understand their
We
predicament.
don't want to say anything on that. What is the situation of employment, unemployment? We don't want to say anything on that.
This particular
We are only
process.
concerned with this recruitment process.
Yes, Your Lordship.
Neither we can hold anyone in this process to be unaffected, since we cannot record a finding before the investigation or the trial concludes, nor there is an occasion to say that you go ahead with the fresh recruitment process. We don't know whether after that they have recruited anyone, they have conducted any procedure.
That status
We don't know.
report can be produced
For
before
what?
the court,
For
Your
what?
Lordship,
For what?
so that the
It will be a
conclusion,
futile exercise. Unless there is an occasion to pass such an order, even if they say we have not done, what will we do?
Your Lordship, in irregular.
So show us the law that we can direct for conducting a
Your Lordship,
recruitment process.
grant me some time. I will produce some judgment.
Come tomorrow. We have understood everything, not
Yes.
today.
Keep your blessed, Your Lordship. I will come tomorrow. It's affidavit of service.
And what you are saying something that the file is pending before the Honorable Chief
Yes,
Justice.
Your Lordship.
Why?
The record of this writ application is before Honorable Chief, in the office of the Honorable Chief Justice, for which we could not
Why?
get. I cannot say, Your Lordship. No, it is already assigned before Honorable Justice Shogata Bhattacharya.
Already assigned?
Yes.
Then you
and
move there. Why you have come here?
I have moved there, Your Lordship. I have moved many a times. He's not, his Lordship is not hearing this matter. For any reason, Mr. Shami Mohammed and myself.
Then you go before the Honorable Single
Lordship, that direction may be given, that it may be heard by the Honorable.
No, we are not going to direct. We'll keep your liberty to raise the issue before the single. There is no occasion for passing any order.
Your Lordship may kindly see the prayer, Your Lordship.
Yes, let us.
For expeditious disposal.
If it
we
is
have prayed.
pending, you have to go there. Nothing can.
I had filed the intervener application, Your Lordship. I had already submitted that on 15th May 2024.
Where is your application number? 2.
Yes, Your Lordship. First is
Let us read it.
section 5 and 2 is the CAN application. The prayer is at page 10, Your Lordship. Expeditious hearing and disposal of the present case at an early date. Prayer 2.
So, therefore, your prayer A, prayer C, and prayer D. Where is the occasion to allow this prayer? You tell us.
Your Lordship, I can submit it tomorrow, Your Lordship, if desires. For prayer 1.
A, C, D, you want us to direct that the result of certain untainted candidates should be published.
Yes,
Wonderful prayer, madam. Who are the untainted candidates? How can we go into this today?
Your Lordship, center-wise, some report may be found, Your Lordship.
Surely not. Not at all.
At
It
least, Your
cannot be
Lordship,
done.
make
We will not enter into the investigation which is being done by an independent agency.
The CID has not submitted any report, Your Lordship.
That's not the scope. That's not the scope of the writ petition. For that, you have other remedies.
No, direction was given by the Honorable Court to submit the report by CID on the next date. So it is yet to be submitted. So expeditious hearing and disposal of this application may be granted, Your Lordship. Prayer 2. It will suffice by the Honorable Single Judge.
For considering which application?
Considering the application of the
Where is
interim
that application? What is the prayer made in that application?
for
Which you want to be
vacating the interim order and for analogous hearing, Your Lordship. Analogous.
that application which is not being heard.
Yes.
Where is that?
It is enclosed with it is the annexure, Your Lordship, with can 1.
Can 1.
Yes, Your Lordship. Today I mistakenly did not carry the on the impression that old matters will be taken up, Your Lordship. So
none of this can be. This prayer cannot be. The FIRs were lodged under orders of the court or otherwise?
otherwise, Your Lordship, before it was lodged and then the writ petitions came before the court. Page 15 has another order of the Honorable Single Bench, Your Lordship, where 67 complaints, including those of the PSC officials, have been filed. And 12 charge sheets have been filed by the state police. Investigation in respect of remaining 47 cases have been taken over by CID. The court directs CID West Bengal to take over prosecution of the 12 charge sheets filed by various police stations of the state. CID may, in its discretion, be at liberty to file additional charge sheet. It is expected that investigation to the remaining 47 cases will be taken over by CID is completed within a period of 4 months from the date. CID West Bengal shall ensure that the investigations are not in any way compromised. The report of CID West Bengal is resealed and returned back to the council appearing for the CID West
What is
Bengal.
the date of the application which you filed?
15th of May 2024, Your Lordship.
So it was filed prior to this order?
No, 25.
15 May 25.
Yes, Your Lordship. The order was passed on 23rd of April 2024.
No, there is another order of 24/5/24.
Yes.
May.
May. The subsequent order which I am reading out, Your Lordship, and after that it was never heard by the Honorable Court.
So you have not challenged any order?
Interim order, Your Lordship, I had prayed for the vacation of the interim order. 23rd of April.
Therefore, tell us, can it be done?
Lordship, I may be granted 1 day time, Your Lordship. Learned Senior Counsel is also willing to get one copy of the application because today she is not having that.
Very.
Served on.
No, I have served once. For the second time, I will serve Your
Take it from your website or whatever. We are not going to saddle them with such a.
I have served already.
If they want to, they can give you amongst yourself. We have
already served them. So Your Lordship may kindly keep
as
it
prayed
tomorrow.
by Page has been changed.
Now 19.
Before my friend starts, my lord, I kindly recollect that I had indicated that in this connection of the same order, my lord, the bank has also preferred an appeal.
Yes.
My lord, I have already, yes, my lord, we have already filed. My lord, if your lordship grants me leave, my lord, I can serve him the copy right now because there is 31 days delay. And that application has to be.
Application is also there.
Yes, yes. Can 1, can 2 are there. Today it is not listed. If your lordship kindly permits, my lord has already granted him leave to get the matter listed. Any day subject to your lordship's convenience, so that both the appeals can be taken up together.
I've been waiting for quite some time.
But any day next week. Any day next week.
On Monday? On Monday?
Tuesday instead of Monday. Tuesday instead of Monday.
Quickly, sir, it is not possible for me to book a ticket and come immediately here. So at least 10 days.
My lord,
But,
may I say, subject to
Tuesday,
what he says, my lord, with regard to the can, probably he can appear online, at least with regard to the can. Let the appeal be registered, thereafter both the appeals can be listed.
Your appeal is on list today.
Not in list today.
I will personally come.
It will be for the can actually appear because it is only for the delay. Main appeal will not be taken.
In my house.
See, what we can do is, there is a 31-day delay. If you want to file opposition, you have the option. If you want to proceed with the appeal, we can pass order on the application and proceed to consider the appeal. What do you want?
Sir, my lord, I don't know that what is the matter in that that appeal objection.
That application, just.
Bench is saying that with regard to the delay, if you want to file any objection, then it is.
There is 31-day delay in filing appeal by them.
Yes, I will object it, sir, my lord.
Because we were of the view, normally such a small delay is not objected. We can notify it at 2 p.m. today. Application can be disposed of today and hearing of the appeal can be fixed. But if you want to file objection, then for the can will be listed for filing objection as you like.
Okay, I can file reply. I will file reply.
All right, then you file it. Give him.
And I'm serving a copy.
We are informed by the learned. Tell him the dates.
2nd July, yeah?
2nd July.
2nd July.
20.
Paying for adjournment till 29th as senior counsel is out of station.
Sorry. No adjournment.
Counsel not in out of station, so
I'm instructed by the clerk of audit to reading the suffering business. Petition.
How many persons are going to mention on his behalf? He has already mentioned.
for the respondent. And for the respondent.
Two persons will mention. This is the third adjournment. Why?
The counsel not in the out of station, so
On earlier two occasions also you have sought an adjournment. Simpliciter adjournment. You are not interested, is 21 matter? Not today, ask him to be here tomorrow.
My lord, I am appearing on behalf of the respondent lead petitioner. Well, it is a state's appeal, my lord. Your
My
lordship.
lord, I am appearing on behalf of the respondent corporation.
She is appearing on behalf of the company. In this matter, my lord, kindly remember, in this matter, what happened? Learned single judge has allowed the regularization of service of the two persons, lead petitioner. Thereafter, my lord, what happened? Thereafter, my lord, they preferred an appeal. Appeal court did not pass any stay order. Thereafter, contempt application come. After passing the issue of rule, my lord, they filed the appeal, and thereafter, my lord, contempt court has held the compliance report is a SAM compliance, and why the principal secretary should not be sent to jail for 3 months. Against that order, my lord, they went before the Supreme Court. Supreme Court ultimately dropped the contempt, but remand back the matter by asking us to ventilate our grievance regarding the mode of regularization. And your lordship was pleased to allow the section 5 in the at this juncture that I will be remediless because the contempt is.
Now we remember, yes.
Yes, my lord, I have filed the application for appropriate order, my lord.
Initially you were inclined to oppose, we said then what will
Yes,
remain?
yes. Yes, because there is no scope for cross appeal because single judge has passed the order in favor of us, and if the contempt proceeding cannot be proceeded, I think my learned friend.
There is none to appear for the state, then dismiss.
State's appeal. Second issue, so far the first issue, first item is concerned, matter went up to the Supreme Court. That is why my lord, your lordship has segregated the issues. So for the second matter is concerned, my lord, considering our order passed by the learned single judge.
If we dismiss in default, you will
My lord, I will be remediless, then I again go for implementation of the order, my lord.
Lordship, let it be restored. Let me get to the department. I mean, this was.
we have granted enough time. We'll grant you 1 week's time. Get prepared.
29. 29th পারবেন তো? 20
You will appear or somebody else?
Actually, that I have because
একটা কপি আপনাকে দিয়ে দিচ্ছি যেটা
actually I basically also stated West Bengal matters. This
আর
is
আমার অ্যাপ্লিকেশনের কপিটাও দিয়ে দিচ্ছি
anyway, the transport department should do. And that can.
ট্রান্সপোর্ট ডিপার্টমেন্ট ওই অনলাইনে
Transport department is a PRO also.
My lord, I am not for the department, I am for the corporation. The department is under the state of West Bengal, has to be represented by the state advocate.
appellant is state has preferred a
Yes.
company is
City transport department.
দিদি একটা কপি দিয়ে দিচ্ছি আমি। Second, get to 20.
Same in 22.
Identical issue. But
No, it is also by the state.
yes,
22 is by the state.
copy দিয়ে দিন।
21 was.
আমি নেই 22 তে আমি
Common order. Corporation and the private respondent are represented.
23.
23 lordship, this is also preferred by this Calcutta State Transport Corporation lordship. Sometime lordship, I mean, technically it is not a state appeal, but
You are not representing the corporation.
I am not in the corporation, that is.
Yes, nobody is appearing.
My lord, I have been instructed, my lord, that by the advocate on record, my lord, Miss Saina Sumi, my lord, she is not well, my lord. She has not come to the court, my lord. Seeking only, my lord, accommodation for the day, my lord. Only, my lord.
That means 23 and
Not
24.
today.
23.
And there are two matters, lordship, 24 also.
Not today.
Grateful, my
25.
Is appearing on behalf of the respondents, my lord, but he is ill. My lord, we have taken adjournment. What have been instructed by his clerk, my lord?
None appears for the appeal.
26. May it please your lordship.
Your Lordship, in this matter, Your Lordship, for the respondent, Mr. Chakravarti is appearing for the respondent, Your Lordship. I am praying 1 week accommodation, Your Lordship.
Lordship, this was an appeal.
Sorry. Yes. You proceed.
Yes. Lordship, in this matter, Lordship, the Honorable Court had held that the decision making, this is relating to a disciplinary inquiry where a punishment was imposed. He held that the procedure was, there was no illegality in the procedure, but had interfered in the order of punishment, Lordship. After finding the facts proved, after finding is, but in the order of punishment, if your lordships are kindly come to.
And there is no cross appeal.
No, there is no cross appeal. There is no. Lordship will kindly come to paragraph 38. That is where he interferes with the punishment. That last paragraph. Accordingly, I am of the view that the petitioner's punishment of reduction of pay by one state in the time scale of pay of rupees so and so in level 4 from so and so for 2 years with a condition of no increments during this period should be upheld. However, the portion of the punishment that the reduction will have the effect of postponing his future increments and the part of punishment related to the suspension period starting from 15th of July 2020 to 28th of January 2021, declaring this period would be treated as not on duty and disqualifying him from pay and allowances should be set aside. Lordship, my humble submission, Lordship, if the court wanted any interference in the order of punishment, where he has held that the facts are in tandem, there is no irregularity. Lordship, he should not have done that. And even if he had done that, it should have been sent back to the authority for deciding the punishment, Lordship. Lordship, on the previous occasion, Lordships had heard the matter in details, and my learned friend had said he would produce some judgments, Lordship. Lordship, I have also got a judgment of the Supreme Court.
Sure.
Here that because Lordship, normally the courts have said that.
So apparently he is satisfied with this punishment now.
If he doesn't come.
Yes.
Lordship, here this is where the courts have directed that if it shocks the conscience of the court, then only can the punishment be interfered with. This is a case where the court had found the punishment to be harsh. And Lordship, on that findings, the appeal court had interfered with the order of punishment, Lordship. That was set aside by the Honorable Supreme Court, Lordship.
Lordship,
আসল কথাটা বলবি না
Lordship.
কথাটা না বললে কি করে
But here there is no substitution of punishment.
No, he has set aside a part of the punishment.
Part of the punishment.
Yes,
There
but
is no
when
substitution of punishment.
he hasn't substituted, but he has said this part to remain and this part to go.
To go, yes.
That is an interference, Lord.
And that is the only issue.
That is the only issue. Otherwise, on the finding of facts, Lordship, the court has
Where is
agreed.
the consideration why he has come to such a conclusion?
Lordship,
My apologies, my lord, for interrupting, my lord. Mr. Orpo Chakravarti, my lord, is there, my lord.
Today is third time, sorry.
My lord,
Ask him to come.
on a circumstance, my lord, there is a bereavement, my lord. There is a funeral rites, my lord, going on today itself, my lord. That is why, my lord, I was praying, my lord. I was not requested.
You did not tell him.
He did not. That is what I am saying.
My lord, I'm sorry, my lord. It is my fault, my lord. I would have informed this, my lord. I beg apologies, my lord. Only for this day, my lord.
Not today.
I'm grateful, my lord.
We'll keep the judgment.
Let the judge.
Number 27 and 28.
27 and 28, Lordship. This is an appeal filed by the state. I have to get the papers. I have to. She will kindly give a week's time. Not today. Yes, focus. If I'm praying for a week's time, Lordship, let me. I'll have to download the papers. Lordship. Thank you.
Your Lordship has heard this matter. Your Lordship may recall this is a matter related to the appointment of the data entry operators. They were initially appointed on the contractual basis. My lord, during when their services were terminated, in view that they are going to engage another set of contractual employees. So that was the principle which was argued. On the basis of that, we have got the order of Atlantic single bench.
Could kindly let me. I could get the papers. Lordship.
Mr. Shishana Bandyopadhyay had argued the matter on behalf of the state. One said Mr. Kollol Vasu is appearing, my lord.
You are for the
I am for one
writ
set of
petitioner.
petitions. Yes, my lord.
You are appearing in both the cases.
My lord, in one case. I am appearing in one case and Mr. Vasu is leading in another.
In the other one.
There are
Both are being taken up together.
both are taken up together
Shata, both are being taken
against
up
the same.
together.
Have to organize now. This is too much. We cannot just adjourn matters now. It's been quite some time since the new panel has come into existence. This cannot continue.
I know.
You have to put your house in order. The court cannot just adjourn matters forever.
We are trying to, but I mean,
No,
Lordship,
something
kind-
is lacking, man. We are of the view that something is lacking. Otherwise, there's nothing which stops you from downloading these things from the website. Everything is there. Just a lack of some diligence on the part of somebody.
Yet for the first time, Lordship.
We are allowing accommodation easily. That doesn't mean you will not take any steps.
But these matters, I mean,
It cannot go on like this forever.
Lordship, I mean,
This has been now 2 months.
Lordship, actually, we've started 2 weeks, Lordship. That is the problem.
About 2
That is
months.
the problem, Lordship.
More than 1.5
I
months.
understand, Lordship, what your Lordships are going
This
through.
can't go on forever.
But these are matters which are appearing for the first time, Lordship. I also have to track down.
No, these matters have earlier been heard. There are so many dates.
Earlier heard out prior to this panel.
So therefore, before us is a state government.
I understand, Lordship. That is why
Before us is the state government.
I understand, Lordship. I'm praying.
It can't go on forever. We are now finding it very difficult to accede to the request on a day-to-day basis. Can't be done. Every day we call out matters only for adjournment. How long this will go on?
Yeah, I understand, Lordship.
Then every case which is taken up after 6 months, if some case is listed for the first time, still you will say that earlier I was not the state council, you adjourn it once.
I'll have to get.
There is no right to a first adjournment when a new panel comes into
We
existence.
have the brief, so we have to download.
We are
after-
conscious that you can very well download it.
Yes, Lordship.
So there is something you have to put in place to get over this situation. It can't go on forever. This is becoming too much. Something has to be done. All the matters every day we are adjourning.
I understand, Lordship.
So you have been, you are here only to seek an adjournment.
Lordship, we are trying to cooperate. Whatever is coming,
No, we don't find anything coming in the last few weeks. At least in these 2 weeks, you should have shown some bona fide in some case that yes, you have made an endeavor to reconstruct or obtain from the website, do something. You can't just seek an adjournment in every matter like this. As prayed by the learned at AGP list. Matter এটা পুরোটা দিকে বলো adjournment বলো হ্যাঁ adjournment বলো না সিলেক্ট করে এখানে select করে ঠিক আছে তারা কথা বলে এই একটু adjust করে দেবে এসএম আবুদুল্লাহ judgment citation marking of the judgment marking যেটা সূত্রতে ওটা ট্যাবে আছে সূত্র দাও Rule 66 আছে
ডিসপোজড অফ হয়ে গেছে একটা ডিসপোজ যেটা 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 হয়নি সেইটা সেই আপিলটা করতে ফাইনাল এটা হচ্ছে
Yes.
একটা ব্রিফ দিতে পারো দেখে এতে আছে or if we look into the judgment there are 27 is very innocuous order passed by the last Chairman, Managing Director is directed to take a decision on the appointment of one of the dependent family member, such and such, in grounds of such and such, from the date of birth. So, Lordship, we have to take a decision. Now, Lordship, whether the NCWA empowers to get a employment. If we read the NCWA, if we read the NCWA, Lordship, we will find that in the course of employment, while discharging duty, if someone is affected, then Lordship, this public employment can be given to him, not following the due process. But if someone is generally sick, deteriorated, can that be given to someone as a right of inheritance? That is the only small question I will be framing before you.
So let us see the provision you're relying upon.
NCW 6 5 6 8 or 6 6 दिले if your lordship kindly I'm sorry my lord there's a class Raksha was 6 for it.
Kindly excuse me, my lord, it's marked.
No, why you are giving one copy, sir?
No, my lord.
You know you are going to rely on this till you are here with only one copy, knowing that you are appearing before a division bench.
What happened? My advocate on record, who is having the interbrief, is very unwell. He fell from the staircase today morning. He has not come to court. So I have my
Falling from the staircase has nothing to do with one copy being submitted. You are here, you had a copy, you could have got another copy done. Where's the question of him being unwell? We are taking it up at 1 o'clock. Since morning, that was enough time to get a copy done.
Lordship is my personal.
Yes, it is your difficulty.
Lordship,
Let us see. Yes, which provision you are in?
9.4.
My lord, allow me then.
You have another copy?
Yes. No, it's marked. Kindly excuse me.
পরেরটাতে একই থাকে চলো যা আছে 6 7 আছে
This is NCWA 6.
Yes, but the court has said 6 because lordship, so far as this employment of the dependent is concerned, that was only decided till 6.
So did you file an opposition before the
No,
same?
I had no opportunity of filing. Court was never, on the first occasion, they argued, court said, all right, let me see whether he is blind or not. I said, my lord, there's no dispute, no quarrel on that. He is. Then, lordship, there is a fault. Because of his blindness, that gentleman did not come to office. And my client initiated a proceedings against him on a unauthorized absentee. And then the committee found that he is genuinely could not come to office. So he was exonerated from that. Then the court said that, see how you have tortured him. Then, lordship, the court said him, send him to the Kalyani AIMS for the medical treatment, because for the time being, we had no medical board system with us.
So according to you, the court has not considered that only if it was in the course of duty?
That question has not.
That's all.
That question has not been considered. So now, if that question is not being considered, whether his eligibility, because lordship, I will placing one judgment before your lordship, one or two judgment, which I will try to demonstrate. I need not to show, but lordship, unless a legal right or a statutory right or a constitutional right is infringed, mandamus cannot be issued. Here the court has issued a mandamus asking me to look into it, whether he has a right which has been infringed. Because the language of para 27 of the judgment impugned, if your lordship kindly see, hence the manager such and such is directed to take a decision on appointment up till this on one of the dependent of on appointment of one of the dependent of this on a compassionate ground in terms of clause 9.4. So once the court directs that in particular this term you consider him, then lordship, whether he comes within the ambit of that clause or not, that has to have some findings. That yes, he comes within that. If he is not coming within that, then lordship, a direction upon me probably is a error in law. That's
And according to you, he is not coming because 9.4.01 one makes it clear that unless
case, because the writ petition says
no, what is no one's case?
Neither their case, not my case, that during terms of employment or
Correct.
discharging
So
duty,
therefore,
he was affected.
you say that he is not eligible because 9.4.01 is not satisfied. Therefore, there is no occasion for the single judge to issue a direction to consider under 9.4.0. This is your case.
Yes. So, lordship, either court has to say that he had an eye problem that deteriorated in his way. Now, there has to be a finding whether that deterioration or something connected with the employment or not. Now, lordship, kindly see, while the writ was filed and he was in service, I said, all right, even for a blind man, I have got certain things to offer you for your employment. Alternative employment, even for someone is blind, someone is short of hearing, we can. What we do, someone is blind, we keep the keys with him, in the doorkeeper, I keep him, and then collect the keys from him. So this is how we manage. So this is a case where he said, no, I filed a writ. I will, now lordship, I will take your lordship to the writ petition. If your lordship kindly takes up the writ petition. Writ petition is at page 23.
So where is this ground that you have just asked? Which ground is this in your memo? That if since it was not occasioned in the discharge of duty, it cannot be considered. Which ground?
Kindly come to 11.
No, that is not. That ground is not there in 11.
Lordship, kindly come to 11. Then lordship 13. And then lordship 15. Lordship, this is all I wanted to argue before you.
But this is not a ground. You have not raised this ground in your memo.
Lordship, this is exactly, if your lordship kindly see, enter attack on this is, even if your lordship kindly come to
Just in which ground you have articulated this submission, that since it was not in the discharge of duty, there is no occasion for anyone to consider his claim under 9.4.0.
kindly come to 4 in
4.
lordship. 4, 5. My entire appeal is on the
Any ground you show discharge of duty is required. Where is this expression in any ground which you have urged in the LPA, in the appeal?
lordship kindly see.
See, it is an issue of fact which can be just seen and read from the grounds. So we are asking you to show. It's not a question of submission. A submission that because the disability is not in discharge of duty, he is disentitled to consideration under 9.4. Where is this ground?
Further, the landed such and such have appreciated that he made out a prayer referred to the before the apex court to determine whether he is fit or unfit for the duty, and it is found to be unfit for the duty. Then compassionate appointment may be given to his son, but the honorable judge, single judge, failed to appreciate that the petitioner did not make out any case in the writ petition, and in other words, no averment that the effect was made in the to that effect in the writ.
You are not showing what you have submitted.
Lordship, if your lordship
Till now you have not shown. We are still giving you opportunity to show that since disability not in discharge of duty, there is no question for direction to consider under 9.4.0.
the way I articulate before your lordship, that language.
We are here to read. We are not here just to listen to you. And they will reply to the grounds which you have urged. They will not reply to anything else. And probably consciously you have not made any such ground in your appeal. Because we have gone through 9.4.02 also. It doesn't end at 1. Perhaps you have seen it. You are regularly representing the organization.
In that case, if your
So therefore you have not said anything like this in the memo. Now any other ground you may say so.
I would
Any other ground you may say so.
language, the way the language.
Sir, we have that issue is over now. Any other ground?
No, that is my sole ground, which I am arguing.
All right.
Is the sole, because if your lordship kindly takes up even 15, the single judge failed to appreciate fact that 9.4 of such is not a force.
Sir, just shows this expression, disability not in discharge of duty, therefore cannot be considered. This is the whole and sole submission you made.
Yes.
Which is not there in the grounds. We are of the view that consciously you have not raised such ground. Because you are knowing 9.4.0.
Lordship can take that view. But what I am saying is, lordship, it's a matter of argument before your lordship that since he invoked 9.4, I said invocation is bad and non-application. That much I say. When I come before your lordship to elaborate my argument, there I say how that is. This is the interpretation I am saying before your lordship. This is what I.
Anyway, we'll consider this submission. We will consider this submission.
Then lordship, if your lordship is not required, but still for my satisfaction, if your lordship.
How you are opposing such a claim, sir? Such a big organization bound by this bipartite settlement or tripartite settlement under the labor laws. How are you opposing such a direction?
Just see alternatively, lordship. This is many a time it falls from.
No, you are trying us to show the alternative. We, despite our best effort, prima facie are not inclined. We are wondering why an appeal has been filed in this case.
Lordship, otherwise, if we lordship.
You are an organization, you can indulge in such luxurious litigation. We know that. But they have to suffer. The workman is suffering, so we will have to keep that in mind also.
But lordship,
while disposing of the appeal.
Also, lordship, if we make that interpretation, we will be deprived.
Forget about interpretation comes where there is any ambiguity. 9.4.02 is clear as daylight. There is no question of any interpretation.
Your lordship,
and you have filed an appeal.
Lordship, I am telling why we have.
Wonderful. Such a direction by the single judge to consider. You say that it should not be done.
Lordship, why am
opposing the claim of a workman with which you are bound to honor under your own settlement. Why you entered into a settlement if you don't want to honor it? Can you go beyond the settlement?
Lordship, these are the questions all fallen from your Lordship is correct. Lordship, no quarrel on that. What we are saying, Lordship, because this compassionate appointment is an exception to the public employment.
We are not on that. That is not an issue here.
It's not an issue.
That is not an issue. Those general submissions which come in every case, they are not applicable here.
That is
Nobody said that you give him a compassionate appointment.
That is the case.
Nobody said that you give him a compassionate
And
appointment.
it takes up.
The court said you consider him under 9.4.0. Admittedly, he is suffering with a disability which keeps him away from work. There is no dispute on this.
No dispute. Lordship, kindly see para 27 then of the.
How many times we'll see that? We already seen it. Reading it twice does not make it different.
Lordship, kindly see a direction to take decision on
Correct, to take decision. Nobody has directed you to do something.
decision on appointment of.
Anyway, we understand your argument. We will consider it, but then we are making it very clear
Yes.
that this is the way you are treating the claim of the workman in violation of a bipartisan settlement. Prima facie, it appears to us. Now we will deal with it and it may follow consequences. You can't chase someone like this, a workman like this. This is a luxurious litigation, sir.
Lordship, please appreciate.
It is a luxurious litigation. Clearly.
Then the compassionate appointment is becoming
Very well, very well. We have understood your that submission. If there is any other submission, you tell us.
Accommodate someone.
Tell us.
Give esgatia to someone to do some more for an employee of
This
mine.
kind of litigation is not appreciated by us. You may proceed any other ground apart from this.
No, Lordship, I have no other ground.
Very well.
Honestly, before your Lordship.
That's all.
Because why I'm only harping on this. If your Lordship.
See, we are making these observations so that you know or you have a idea of what is going on in the court's mind. After this, therefore, we are all the more. If you had been a private organization, we would not have made such submissions.
I would have then suggested them. Or
If it was a private organization, we would not have made such observations. All the more, you are under Article 12. What is this, sir? Generating litigation for no purpose.
Lordship is.
And dragging the workman here before the division bench after the single judge, such an order is being challenged.
This is,
there has to be a limit.
No, what fallen from your Lordship, I bowed down before that and I fully appreciate it. But Lordship, the other aspect of it.
Sir, we are inclined to give you an opportunity to take instructions. Come back on Monday. We will pass the order.
Look at record is also not here and then otherwise Lordship.
After some arguments, we enable the learned.
Definitely
Yes.
try to convey my advocate on record as client as well. Try to.
Since 2019, I did not receive.
See, let's please.
Such a single form. May I take back so
It
that I can
give it. Please give us one more copy.
I'll bring next day, Malak.
Next day, Lordship, this will be not repeated. Not only next day in this matter, and no matter.
Sometimes it happens, but please.
I'm sorry. I'm extremely sorry.
Deeply
I beg to appear virtually, my lords.
Yes.
My lords, this is a change brief. I would like to inform my lords at the outset.
Something is pending before the
Supreme Court. The issue, it
But,
has been disposed of. So, my lord, it is a dispute between the petitioners and the Air India. The issue was whether Air India after the disinvestment, whether writ petition will be maintainable or not. Bombay High Court had passed an order, my lord, holding that writ petition won't be maintainable after that. That has possibly been upheld by the
Well, that has been upheld by the Supreme Court in judgment dated 16th May 2024. Well, before I make any further submission, my lord, I'd like to inform the court, my lord, this is a change brief. While I have obtained the no objection from the erstwhile advocate on record, I am not able to file my wakalatnama because my wakalatnama does not state as to which district the matter pertains to. And because I do not have custody of any of the records, nor does my client, I am not able to file my wakalatnama. But if an order can be given to that effect, so that the department accepts my wakalatnama, I can get the cause papers by applying for the certified copy.
The appellant is Air India possibly, my lord. Air India is the
I'm
appellant.
appealing for Air India, my lord. So I'm appealing for the appellant.
No, you organize your brief from your erstwhile counsel. Why we should get
My
into
lord,
this?
my lord, I had
You
approached
don't
the
know.
erstwhile.
Every day if a new counsel comes, it can't be adjourned
My lord,
like this.
this is not be the case, my lord. I approached the erstwhile, my lord.
You do whatever you want to do for filing the wakalatnama. We are not going to say anything. We are just giving you a last opportunity. That we'll see. This
My lord,
matter is the MAT of 2012. Every day,
my lord,
the
the matter
counsel.
was heard and reserved for judgment in 2022 because the issue was pending before the. There is an order. I can show, my lord.
Just
There is
now
an
you
order.
said you don't have any records. Now you are reading the orders
My lord,
from the
orders from the website of this honorable court, my lord.
Just now you said you don't have any records.
My lord, I don't have any
And
records
now
of
you
the
are
cause
making
paper.
submissions.
My lord, the order is available on the website of this honorable court, my lord.
Not for judgment, as far as I know, my lord, it was directed to go out of the list because of the pendency of the.
My lord, I'll indicate, my lord. In the order dated 28th
Nothing. You
November.
file your wakalatnama. You are Mr. So and so.
My lord,
Submits that
kindly.
he has to file a wakalatnama. Let him do
Let us respect, this is not the time of mentioning, my lord. With regard to item number 16, my lord, I was on my legs. My junior, my lord, prayed for probably Passover or not. My lord, it was fixed 2 weeks. My lord, ready with the matter. If your lordship kindly makes it not today. It will be my pleasure and privilege to argue in that matter before your lordship, my lord.
Why we have adjourned for 2 weeks?
Well, that I don't know. I told my junior.
Who have made the prayer?
My lord, she is not here, my lord. My
But
lord,
he was appearing for the other side.
petitioner.
For,
That's not the petitioner.
for the other side.
No, not for the other side. My lord, on my behalf, my lord.
No, was anyone appearing for the other side?
My lord, probably not, my lord.
No, not probably. You have to tell us.
Then, my lord, I will.
You find out. You find out. Yes.
I will come on Monday, my lord. That will be better. Good.
Item 1, my lord, this is that matter, my lord, where the interest component, my lord, is an issue. I would humbly request your lordship, my lord, the condition of my client is such that it's becoming very difficult to pursue the litigation because she hasn't got anything, my lord. Though she has challenged, and request your lordship to take it up, my lord. On the last 2 days, my lord, because of them, my lord, on one ground or the other, it was adjourned. She is in dire stress, my lord, I can tell your lordship.
All these matters are one and the same.
Same. One following the other. Others have settled, my lord.
No. Only one party, only one person has settled.
Very well, whatever. But these are all.
That is over.
Yes, Hila.
Over.
Others have not.
Very well. Let us.
Point is very short, my lord. Kindly, my lord, comes, my lord, to the read petition. I will show your lordship 3-4 paragraphs. Then straightway I will go to the law, my lord. Whether interest, my lord, can be granted or not. I'm sorry, my lord. May I, my lord?
Just
very.
You are the appellant.
I am the appellant.
Then why are you on this side?
No, my lord. I have a cross appeal. Lordship is absolutely correct, my lord.
Lordship,
I have a
item
cross
number one,
appeal.
we are the appellant. They have preferred the cross appeal.
Oh.
Or
My
the
cross
interest
appeal is
component.
only with regard to the interest component, and they have challenged the order because they were directed to pay compensation, my lord.
No, that now is settled because they have
Yes,
given to
yes.
others. So only whether you will get interest or not, that is the only thing.
Yes. My lord, I would not take more than half an hour, my lord. My lord, facts are, my lord, my client's, my lord, husband, he passed away in 2002 while he was in service.
30/12/2002.
Absolutely, my lord.
Yes.
Now, after that, my lord, an application was made for compassionate appointment because she was less than 45. That was not considered. First representation came from my client's side in 2016, not considered. Then final representation came in 2024, which was also not considered.
Where is the first representation?
Kolkata. Page 73, Lordship would kindly comes to Mullet of my read petition for it. Stay petition. For it. Huh? Page 73.
73.
73.
Application from our.
আমাকে দেখাও কথাটা কোনটা
73
of the stay petition, my lord,
Maybe
APOT number 267, GA number ta bol. GA number 2, my lord. তো বলটা বলো না কিন্তু কি পাতাটা বলো হ্যাঁ উফ, সময়টা বলো Lordship has got it, my lord. At the bottom, Lordship will find the date 18/10/2016. It's cryptic, but my lord, a representation was made, which was not considered. Then, my lord, Lordship would kindly comes to page 78. Date. পারে না একটা 2016 এ ছিল দেখালাম 24 page 78 the next representation, final representation. Since no appointment was given, we prayed for monetary compensation. Nothing was informed.
Yes.
Then, my lord, we filed a read petition. Finally, my lord, when the read petition was filed, they informed us in the form of a report that you are not entitled to get this. That is page 83. These are all admitted position. Page 83 is the report. But page 85, paragraph 6, if Lordship sees, they have talked about the petitioner's request for employment. And then next paragraph onwards. Paragraph 5, 6, 7, Millard.
Where is R1?
Millard.
Where
What
is
R1? R1 page 89. What a key. Rules যেটা বলছিলে. That is, Millard, the Social Security, Chapter 9, the relevant rules, Millard, probably what applies. Page 90. No, 89. R1 is 89. তাহলে উল্টো বলো না.
Where is the rejection of your claim?
Well, rejection, Lordship will find that has been stated in paragraph 5 onwards in the report, which was filed by you of an affidavit. 5 and 6, if Lordship sees, that has been rejected. Employment.
No, it says the authority rightly rejected the request. When did it reject?
But that we came to know, unfortunately, when the read petition was filed and first time when the report was filed. That is one of my grievance. I was entitled to make an application for compassionate appointment because my husband died while he was in service. You took almost 20 years or maybe more than that.
So apart from you, who else was there in the family?
Milord?
Apart from you, who else is there in the family?
Milord, my son-in-law, whose name has been recommended by me.
And your daughter?
Daughter's name has not been recommended. Son-in-law's name was recommended. But there was no dispute. Daughter never raised any objection. There was no objection.
So your family comprises of you, your daughter and son-in-law?
Yes. That's why, my lord, I claim interest, my lord. These are the facts, my lord. And in the impugned order, my lord, I'm sorry. Order to work or impugned order. But the impugned order, my lord, is at page 97.
And where is your application?
My lord,
Which- The first one is of 2016, or there is one prior there too also.
that is, my lord, a representation made formal application করেছিলাম আমরা. That is, my lord, page 73, application for MMCC against my husband. Page 73, which I had shown to your lordship. 18th October 2016.
No.
I'm telling you. Yeah?
It is some application prior to this.
Yes, yes.
Because it refers to earlier submission of
Absolutely.
documents.
Page 68, my lord. Seeking employment. বদিটাকে the bunch of documents, page 63 onwards, nomination, page 66. Then, my lord, page 68 কি বলছে? Page 68 is the application. Prayer is made for employment in respect of my son-in-law, Ashok Bouri, under the subject caption. And petitioner has made this application. And lordship would find, my lord, from page 68, application, my lord, was filed on 30th December 2002 at the top, page 68. Entire issue was kept pending. I was not given anything until the report surfaced when the writ petition was filed.
Yes.
Now, my lord, kindly comes to the impugned order where I am aggrieved. Page 97, the impugned order starts. I am not placing that portion. Paragraph 21, running page 111, is the paragraph where my claim for interest was declined. Running page 111, internal page 15, paragraph 21. The learned single judge held, my lord, it's a completely the discretion of the court, and the court thought in this case the interest could not have been granted. We have strongly relied upon two decisions, Sumi Kamin and Putul Robidas, that has been quoted. I would not trouble your lordship. I will be relying on that. Paragraph 21, which I am agreed with. The learned judge, my lord, in this paragraph records grant of interest also depends on equity considering the facts and circumstances of the case. After recording this, the learned judge further held, in the instance, admittedly, since after the submission of the application, the petitioner is also not pursued. I have made representation, onus was on them, not on me, my lord. Once I made the application, completed the formalities, it was on them to inform, though I made 2 representations. Had it been my fault, my lord, it could have been different. And no reply to my representations, lordship will kindly take note. She is not a literate lady, my lord, had severe financial issues.
Yes.
Now, my lord, kindly comes to my compilation. Under this facts, my lord, I pray for interest as well as the my lord, compensation based on, my lord, the law laid down by this honorable court on many occasions, and also the Supreme Court upholding the decisions of this court. Quantum of interest is, of course, the discretion of the court. Some courts said 8, some said 12, my lord. That is up to my lords, my lord, to decide. Kindly, my lord, takes up the first decision. That is Putul Robidas, my lord. I have mentioned the pages, my lord, page 6 to 27. I will only indicate the relevant paragraph. Kindly comes to page 25 of that judgment, my lord. Compilation, lordships have got it, my lord. Not this one, my lord, probably. Contact to what? The other one, my lord.
It is extracted in the order of the single judge.
Yes.
You want to rely on that portion or some other portion?
No, some other judgments also.
No, the portion extracted in the honorable single judge order, you want to refer to those regarding Putul Ravidas or some other? He has recorded paragraph 66, 67.
Paragraph 66, my lord, I rely upon.
Yes.
Only one portion, my lord. Paragraph 66, my lord. The lordship comes to last few lines, five or 6 lines. I will not trouble your lordship more. Paragraph 66, page 24. Then next page kindly turns to page 25. Last 4 lines, 5 lines, even no application, lordship will find the sentence starts.
Yes.
No application was required to be made. Suo moto, it could have been done. Here, my lord, I have made an application. কোথায় সেটা? Page 28 টা কি? দেখা ওটা। So there, my lord, also we did not get, the petitioner did not get anything. Matter was withheld.
The court did not award any interest.
My lord,
The court did not award any interest in that case.
court did not award interest. Court decided that the right to claim interest and the entitlement of the petitioner to claim interest, that is what the court decided in that judgment, and court said no formal application necessary. Relating to awarding interest, my lord, I have annexed several judgments. Now, my lord, kindly, my lord, comes to serial number 2. The consistent view of the court, my lord, is first, second, third, fourth, fifth heading. I have indicated para 14, page 28 to 37. That is another judgment. Division bench of this honorable court, presided over by Justice Subroto Talukdar, and the companion judge was Justice Lopita Banerjee. Page 28. Single bench order was challenged, my lord. Lordship, my lord, would kindly...
You are referring to the compilation?
Compilation, my compilation, where all the judgments I have given, my lord.
Page 28.
Page 28. I have indicated the page numbers also. Yes, that one, my lord. First one I have shown you from page 6 to 27, Putul Robidas. Second one, page 28 to 37. But in this judgment, paragraph 11 onwards, if Lordship looks into, Lordship would find the facts have been narrated. That there, my lord, the petitioner had to wait about 34 years. And Lordship will find, my lord, from the clauses which I would show. One is prior to 45, then after 45. Prior to 45, my lord, no prayer could have been made for monetary compensation. But the moment after she crosses the age of 45, she was otherwise entitled to. So either compensation or entitlement to compassionate appointment. That was the age limit. Now, my lord, kindly, my lord, turns to clauses have been narrated. Paragraph 14, my lord, to cut short. Trial court's order allowing compensation and interest was accepted by the division bench. Para 14. May I, my lord? In the light of the discussion above, the bench finds no reason to interfere with the impugned order dated. My lord has got it, my lord?
Yes.
April 18, 2022, passed by the Honorable Single Bench. The said order is only to be modified to the extent that the areas of MMCC, monetary compensation, to be paid by the appellant will be from April 22, 2002 till September 30, 2022 at the prevailing from time to time with interest payable at 6% per annum by September 15, 2022. Single bench awarded 3%, division bench said 6%. Paragraph 11, I showed your lordship, the my lord, single bench has awarded 3%. And this is because of delay and absolute inaction on the part of the authority. Then, my lord, the next one. Next is Ulto Bulj. Another judgment, my lord, page 38 to 47. All on identical issues. And there, my lord, SLP was dismissed also. SLP preferred dismiss. Next judgment is, my lord, page 38 to 47. Relevant paragraph is paragraph 10. That is also division bench by the same bench, my lord, in respect of another matter, my lord. Clauses were interpreted, my lord. Then last paragraph 9 and 10 at page 45. Single bench order was not interfered with, my lord, and paragraph 10 discusses about the quantum of interest
50,000 cost also.
And also cost was imposed for prolonging the issue. That is paragraph 11 on ECL because of delaying the issue. Next judgment, my lord, is page 48 to 49. I have annexed. Only indicate the relevant paragraph, my lord. Paragraphs also have been mentioned, my lord. Lordship will find paragraph 28, 29, 30, 31, 35, 36, 45, and 46. But Lordship would only look into paragraph 45. Page 58. May I just place two paragraphs? No materials are placed before us that MMCC was ever offered to the writ petitioner. The authorities appear to be sitting tight over the entitlement of the private respondent and have now come up with a case of stale claim. Quite identical with our case, because in the affidavit, by way of a report, they said you are not entitled, and that too after 22 years. In fact, in the circumstances of the present case, no delay can be attributed to the petitioner. Not only that, in view of the ratio laid down in the case of Kajoli Boudi, Supra, it is the appellant who was at fault firstly by not offering the entitlement of the writ petitioner, by not offering. So onus on them, what I was arguing. And secondly, by not guiding her through to put in her claim. It's very easy, my lord, after 10 years to say that you have not done this. But you have to give an explanation which you did not do for 22 years. Then paragraph 46, my lord. In the light of discussions made herein above, we find no material to interfere with the findings of the learned single judge as to the entitlement of the private respondent in respect of MMCC on account of death of her husband from the date of the following date. We find no reason to with the direction of the payment of interest on the due amount with effect from such date. So appeal was dismissed. Then, my lord, I'm sorry, bro.
Yes.
Next judgment, page 63 to 71. That is, my lord, of the Honorable Supreme Court's view. Page 70, if Lordship kindly comes to. This is the consistent view, not only of our court, but also of the apex court, my lord. Page 70, Lordship will find the direction of the Honorable Supreme Court. The interest of justice would be made and complete justice to the appellant will be rendered in case the appeal is disposed of as follows. The second respondent is directed to appoint one son of the appellant who has otherwise become major as of now as per the choice of the appellant within 2 months from the. Needless to say that the appointment will be commensurate with the qualification entitlement of the incumbent. From 1/2/2004, an order as ordered by the High Court, the appellant shall be paid 3,000 per month along with interest at the rate of 7.5%. So interest, monetary compensation, as well as the job, employment, all given. And cost, I think. Yes. Lump sum amount of 5 lakhs. Now, my lord, the next one, our High Court's view, my lord, page 72 to 100. Kindly take note of paragraph 38. I will not trouble your lordship, my lord, to read the judgment. Paragraph 38, 72 to 100. There, my lord, 2 appeals were taken up together. Page 72, lordship will find identical appeal of ECL as well as the cross appeal of the private litigant. Page 72. For enhancement of interest. Lordship will find 2 APOT numbers, my lord. Page 72, my lord. So both appeals were taken up together. Then, my lord, the relevant paragraph is para 38. Paragraph 1 narrates the facts. Paragraph 1, lordship can also consider, my lord, here, relating to the facts. How the 2 appeal, my lord, came up. May I, my lord, these intra-court appeals have been filed by both parties against the judgment and order dated so-and-so. My lord has got that. Allowing the prayer of the writ petitioner so-and-so for a claim of monthly monetary cash compensation and directing the appellant authority to pay the same from the date of death of a mother, that is 22nd November 2000 with interest at 6%. The appellant authority challenged the order, the authority also, on the ground of wrong interpretation by the learned judge in respect of the facts of the case and settled them with the interest. So there were two appeals, both were taken up together. Now, my lord, the view of the division bench, Lordship will find, my lord, at paragraph 38. At page 99, my lord.
Yes.
In view of the various judicial pronouncement, it is settled that the monetary compensation or the compassionate appointment in terms of NCWA is not a matter of any bounty to be distributed by the authorities, but valuable rights of the workmen attached to the company, and any delay in settlement and disbursement should be viewed seriously and dealt with severely by imposing penalty in the form of payment of interest. That is, my lord, the view. And court, my lord, enhanced it from 6 to 7.5 division bench. Then, my lord,
In this case, they have made the payment otherwise.
no, nothing. No employment, no payment, nothing.
Employment they have rejected, perhaps.
My lord,
Employment they have rejected.
everything. And that too, my lord, after 22 years, I could have made a monetary compensation claim, MMCC. Had I crossed the age of 45, I was less than 45. So only option I had to make an application for compassionate appointment, which I did. Requested them to appoint my.
So below 45, you will not get MMCC.
Lord, I can. It's not an absolute, but either or. I'm sorry, my lord. Lordship is absolutely either or. So I chose for the Lord, employment.
You wanted your son-in-law to be employed.
Yes. Either or. I'm sorry, Lordship was absolutely correct. Either or. Now, my lord, Sumin coming to Kota? Yes, my lord, I have more or less, my lord, I have shown the other two judgments, last two, on the same, my lord, page 101 to 108, paragraph 7 and 8 I have indicated on identical issue, my lord. Page 101 to 108, paragraph 7 and 8. What? 107, Lordship will find, my lord, they're also relied on that 9.5, 9.3 clause, my lord. And court did not interfere with the impugned order, with the trial court's order. And trial court awarded interest. Trial court awarded interest, that Lordship will find, my lord, at page 103. (102, 103), first paragraph. Trial court's observation and finding, my lord would find there was a direction to pay interest. The last one, my lord, is 109 to 117. 116, there, my lord, the SLP was dismissed, my lord. Challenging an order. 116. Huh? 116, if Lordship kindly comes to, this is also a division bench, my lord. Page 116, subparagraph I, if Lordship takes note of it. H and I. Same view, my lord. One 116. 103. ওকে একটা পাতা দিয়ে তো বলছি one 116 মিনিট মিলছে না পাতা Lordship will find Milord from from the discussions, it is apparent that MMCC is to be paid to the writ petitioner from the date of employee as such the order of the single bench directing the ECL to pay MMC to writ petitioner from that day, being the date of death of so-and-so, the employee, along with arrear at the prevailing rate from time to time between so-and-so and so-and-so with interest at the rate of 6%. Then below next page, her husband who was employee till the writ petitioner who attains the age of 62 years or expires, whichever is earlier. In addition, the rate of interest of 6% which has been imposed is not at all exorbitant.
You are reading which page?
Page 116 and 117.
Yes, that you have already.
I is the final finding, below. Okay. These are the judgments, my lord, I wanted to rely upon. And my lord, there's another judgment, my lord, I want to rely upon, which is not in the compilation. Supposing, my lord, in a case where there is no procedure has been prescribed or method has been prescribed for awarding interest, what would be the principle or the guiding factors the court will consider? Now, do copy them. That is below 2008, volume 3, Supreme Court cases, 44. Paragraph 14, paragraph 14. এখানে ইন্টারেস্ট দেওয়ার কোনো কথা বলা নেই না তোমার মামলায় পেজ 14 একটা কপি দাও ওদের আমারটা নিয়ে না না অসুবিধা নেই প্যারাগ্রাফ 14 মিনিট in the circumstances my lord has got it আমি দিয়ে দিচ্ছি এটাই In the circumstances, prima facie we are of the view that the grievance voiced by the appellant appears to be well-founded that he would be entitled to interest on such benefits. If there are statutory rules occupying the field, the appellant could claim payment of interest relying on such rules. If there are administrative instructions, guidelines, or norms prescribed for the purpose, the appellant may claim interest benefit of interest on that basis. But even in the absence of statutory rules, administrative instructions, or guidelines, an employee can claim interest under Part 3 of the Constitution, relying on Article 14, 19, and 21 of the Constitution. The submission of the learned counsel for the appellant that retirement benefits are not in the nature of bounty is, in our opinion, well-founded and needs no authority in support thereof. In view of the matter, in consider the High Court was not right in dismissing the petition limine even without issuing notice to the respondents. কেন মানে
প্যারাগ্রাফ 9টা পড়ি
কেন বলো
আমি বলেছি যে উনি 10 বছর আগে টাকা পাওয়ার কথা কিন্তু সেটা যদি না দেয় তাহলে সেই টাকাটা অ্যাক্রুড ইন্টারেস্ট বাই দ্য স্টেট
These are the judgments, my lord. My learned junior insists, my lord, to cite one more judgment, my lord. 2007, volume 3, Supreme Court cases, my lord, page 545.
Give us
paragraph 9. If there is a delay, paragraph 9. Paragraph 9, if lordship considers. Page 547. What is interest, my lord? That has been explained here. First sentence, my lord, is good enough, my lord. It may be paragraph 9, my lord. It may be mentioned that there is a misconception about interest. Interest is not a penalty or punishment at all, but it is the normal accretion on capital. For example, then an example is being given. If I am entitled to compensation, my lord, because of not giving me the employment, then, my lord, had I invested the money, there would have been an accretion. and that has been prevented by the wrongful act by the respondent. But these are my submissions, my lord. The relevant rules, my lord, I would not trouble your lordship. 9.5, I have also given it.
See,
9.5.
there is no dispute that you are entitled to MMCC. There is no dispute that MMCC is to be paid just after the date of demise.
Absolutely.
The point is, they say you have approached late or you have agitated your claim late, not followed it up. Therefore, there is a delay. That is what the court has found sufficient to deny interest.
Absolutely. Now, my lord, the point is court said discretion. Now, my lord, three things I would submit, my lord, after citing the judgments, my lord. In one of the judgments, my lord, the presiding judge was Justice Talukdar, lordship has taken note of it. Court says the duty of the employee's representative is to make an application, even not an application that is held by Justice Dipankar Datta. That is ultimatum for me. The moment I make an application for compassionate appointment, my onus is discharged. If there is any fault or any discrepancy, it is the duty of the authority to point me out. Now, in this case, what they did, Millard, after I made the application in 2002 and made 2 representations for MMCC because they were not giving me employment, they kept mum. They did not do anything until 2024 when they say there was some anomaly. Will the court believe it without any contemporaneous evidence?
So you are in appeal only for the interest?
Only for the interest because the compensation has been given. These are my submissions, for that I will not trouble
Yes.
you. Issue is very short.
Lordship, since my learned senior friend ended on the point of interest, what is interest? I would also like to elaborate a few things about interest. What do we mean by interest in general, without referring to any judgments? Lordship, the concept of interest, as I understand, is that it is to compensate for certain kind of opportunity loss. It is in a way a compensation for time value of money. My lordship, in my submission, if one seeks compensation for time value of money, one needs to also respect time. Because your lordship, what happened in this case, if your lordship may see, in the year 2002, the claimant, his husband, her husband, she died in the year 2002. He died in the year 2002. And thereafter, she made an representation, no doubt, that has been pointed out by a learned friend. Lordship,
So that 2002 application, 16 and 24 representation is not in dispute.
Yes, your lordship. Now, your lordship, this application was made in the year 2002. This has reference to NCWA. Now, your lordship has rightly pointed out that NCWA, this is binding between the employer and the employee. Now, your lordship, NCWA provision 9.5.0. It says that provision for employment, monetary compensation to female dependents of workmen who die while in service and who are declared medically unfit under clause 9.4.0 above would be regulated as under. Now, clause 2 says, in case of total or permanent disablement due to cause other than death, other than mine accident and medical unfitness under clause 9.4.0, if the female dependent is below the age of 45 years, she will have the option to either to accept monetary compensation of rupees 3,000 per month or employment. So she had the option to seek employment for herself, but she chose for employment for a son-in-law. Now, your lordship, for the son-in-law, the rule is that dependents have. Lordship, clause 9.4.03. The dependents for this purpose means the wife or husband, as the case may be, unmarried daughter, son, and legally adopted son. If no such direct, lordship, your lordship has the NCWA.
Yes, we have it.
If
You're
no
referring
such
to 9.4.0.
Yes, 9.0. Clause 3.
3.
I'll just read once again. The dependent for this purpose means the wife or husband, as the case may be, unmarried daughter, son, and legally adopted son. If no such direct dependent is available for employment, then brother, widowed daughter-in-law, or son-in-law residing with the employee and almost wholly dependent on the earning of the employee may be considered. So, Lordship, there is a catch. If if anyone is seeking employment for son-in-law, it has to be established that certain conditions are met, preconditions are met. Only then you can seek employment for son-in-law. If that is not met, then automatically you are disqualified. And your lordship, it is, since this is binding agreement to in my submission,
Disqualified for the compassionate appointment.
compassionate appointment, yes, and then she could have applied for MMCC if she would have wanted. That I'm not disputing. But your lordship, applying after the gap of in the year 2016.
So therefore, we ask you 2002 application, 2016 representation, and 2024 representation. There is no denial that these three were submitted. There is no denial. In 2002, what does she claim?
2002, she claimed employment for her son.
Please read.
Therefore, employment in respect of my son-in-law, Ashok Baudi, in place of my deceased husband, late Bodhi Baudi. This one. I, Srimati Maya Baudi, wife of late Bodhi Baudi, beg to state that my husband expired on 7/7/2002 at Central Hospital, Kolkata. I have already informed regarding the death of my husband along with certificate of my deceased husband. Now I pray before your good self to kindly arrange for my wholly dependent son-in-law, Sri Ashok Baudi. Application for employment of my wholly dependent son-in-law is also enclosed for your ear. So, Lordship, they have only stated that my wholly dependent, but has she stated that he resides with them, and has she given any proof that my dependent son-in-law, so-called dependent son-in-law, does not have any other
There is
source of
some
income?
application prior to this also.
Lordship, there prior to this.
Yes.
No, Your Lordship, there was no application prior to this. This is the first application they made.
What is the date of death?
Date of death is 7 July 2002.
There is some application prior to this. I have already informed regarding the death of my husband along with the certificate of my deceased husband. She states, where is that application?
That is not the date of information about the date, but the application was date 66.
That was only an intimation regarding
Yes,
death.
yes. Within 4 months, I made the application.
Yeah, where have you stated about that application?
That, my lord, I have stated.
So that means prior to this December 2012, there is no application for compassionate appointment.
I passed away, then I informed, then the application came.
No, so therefore prior to this, there was no application.
No. Paragraph 5 of my writ petition, page ta bolo, page 36 of the stay petition. Right? Page 36, running page, paragraph 5.
No, para 5.
Para 5.
Para 5 doesn't mention about the earlier intimation.
Para 5
starts with 3/12/2002.
Para 5 mentions about the date consequent upon the death.
Yes, she nominated her son-in-law by that application of 31/12/2002, which is at page 68.
Lordship.
Please come to page 68, second paragraph of that application.
Page 68.
I have
already informed regarding the
when. That is what we are asking you.
That when the information was actually given, the date of death, that has not been mentioned. Not mentioned.
But there is something prior to this also.
In between has to be, because I have already said.
Therefore, we are saying we are trying to ascertain.
No, that date has not been mentioned, but any time in between.
So it
within the 5
what
months.
was the date of demise? 7/7.
7/7.
It must be between 7/7 and 31/12.
Last date of application. Absolutely, my lord. I'm grateful to your lordship. And since lordship is looking into this, my lord, kindly, my lord, take note of one rules, my lord. My learned friend is submitting 9.3.3. Take note of this. Relating to dependents' right to get employed.
Since now you are confining to interest, there is no question of going into
Just the relevant clause. 9.3.3 permits. That's all. permit.
Because in the applications that he has submitted, he has also submitted an affidavit saying that he was dependent and
Yes.
that is there. But
Absolutely,
since that is not, now you are confining to
undisputed, no controvert. Nothing has been controverted, document-wise.
Lordship, they might have informed. I'm not. Maybe just an oral intimation regarding death. So this is the first application they made after the death of death, claiming employment for son-in-law, which they are not ideally allowed to under the provisions of NCW unless they furnish clear proof that the son-in-law is residing with me and that the son-in-law is wholly dependent on
that
the
issue is not relevant
Yes,
now.
yes.
They are not claiming a
Lordship, no.
It is only now for interest only.
For interest, as I was saying, Lordship, the aspect of interest is that it unless there is any statute, for example, there are few statutes. Lordship may, for instance, take MSME Act 2016.
What?
Lordship, I'm just carrying one.
Why you are showing MSME Act?
Lordship, I'm just
How is that
showing-
relevant? There is a provision for interest in so many statutes.
Yes, Your
Should we
Lordship.
consider all the statutes?
No, Your Lordship, what I'm saying is that if a statute provides for
That you have
interest,
yes, submitted, unless there is a provision for interest, it should not be granted. That
sometimes there are provisions for interest. Yes. In that case, obviously courts are bound to grant interest. There is no denying that. But in other cases, for example, as the general provision of the Interest Act says, that paying of interest is something entirely in the discretion of the court, unless there is something specifically stated in the statute or there is an agreement to that effect. Even the arbitration,
unless the discretion is circumscribed by statutory provisions, the court will act in exercise of its discretion judiciously, considering the facts and circumstances of the case. Yes.
Exactly. I bow down, Lordship. And I was just citing a few examples. That is all. Now,
no, there are hundreds of statutes
Yes,
which
yes,
have
Lordship.
interest component. We need not go into all that.
Yes. Coming to this present case, they are claiming that the applicant is illiterate. She had no other way. But Your Lordship, on the other hand, also for claiming employment for MMCC, as we all know, Lordship, if a person sleeps over their application for a very long time, it also indicates that there is also not that much urgency. Lordship, they could have followed up with a few more applications. Also, if they would have wanted from 2002 till 2016, there is nothing on record.
No,
And-
you see, the Honorable Single Judge has proceeded on the premise that till 24 there is nothing done. He has not even considered a 2016
Even
representation.
2016, it has not been considered. But in 24, that makes a year gap of 22 years. And Your Lordship, this decision regarding rejection, as Your Lordship may see in page 76. Yeah, of the state petition, it is not like the no decision was taken. Lordship may see page 77. After Lordship, page 77, Maya body, number D, in para number 9, starting from the previous page. After examination of each of employment file, we can say now that it is not possible to process due to all case file are not eligible as per norms of NCW and as per internal circular of ECL. Most of the employment files are lack of documents and incomplete. Moreover, it is more than 5 years old and onwards, except serial number C, who has been processed as per norms of NCWA. So, Your Lordship, a decision was taken. Also, it is not that a decision was not taken.
Decision on what?
On this is an internal in the meeting.
So how is this relevant? This will not determine the rights. This is something in your organization. How is she concerned with that? She has nothing to do with it. Unless there is a communication, how it can affect the right of the party. There are so many decisions in internal, moving from one desk to the other, one authority to the other, that will not form the basis of determination of any rights unless it was communicated. If it had been communicated, she chose not to challenge such a decision, then there may be a. You keep deliberating and you don't tell her anything. What is to be done?
Lordship, there could It is my case that they could also have followed up with a
That you have said,
yes, yes.
that you have said that there is a delay.
There is a
They have
yes.
not acted with diligence. They were required to act with due diligence. Even in 2002, they have only raised an issue for compassionate appointment.
for
They
the
have
same.
not raised a claim for MMCC till 2016, and therefore the court has rightly not exercised jurisdiction.
I am relying on the courts. I am totally supporting the court judgment on this aspect that it is a total discretion of the court, and it is because of their conduct in not being diligent that they should not be granted that interest as they are claiming for, and the interest has been rightly rejected. And it is a very well established law that laches and delay on the part of a petitioner can disentitles them to remedies from the court. Your Lordship, I have also submitted a few judgments in my compilation.
Yes.
Lordship, in my compilation, page 36.
Yes, sir.
Lordship, this is a judgment relating to, this is not related to NCW, I'll be upfront. This is relating to Motor Vehicles Act, and there was an aspect of a person claiming for compensation in the year 2005. I am only on the aspect of delay and latches in approaching the writ court. Lordship, since they have come up with a lot of judgments on interest, I'll have to deal with that separately. And if your Lordship may grant me, I will file a compilation for interest, saying that the interest is something on the discretion of the court. But your Lordship, probably it is not that much necessary also, because your Lordship is well aware. This is only on the aspect of delay and latches. What happened in this case was that in 1977, there was a death, and a person made application for compensation in the year 2005.
How many years after?
28 years later.
And the statute required within 6 months.
Within 6 months, it is under 6 months. There was an abolition, there was a removal of that provision by way of amendment, but subsequently it was again earlier there was 6 months limitation period, but thereafter there was an amendment, and this provision was deleted, and no limitation has been applicable from the year 1994 onwards. Now, Lordship, para 6.
What is the date? Which year death occurred? 1990?
1994, there was an amendment.
No, when the death occurred.
Death occurred in the year 1977.
And the time limit was removed in 94.
It was removed in 94. And they were relying on this provision for claiming that since there is no time limit for claiming compensation, we can come at any point of time.
So what the court held?
Now, Lordship, one observation of this court. Para 6. It would, para 6, page 42. She has got it. It would, however, be pertinent to mention that the period of limitation provided under section 166 clause 3 aforementioned was completely done away with effect from 14/11/1994, as section 163(6)(3) came to be deleted from the Motor Vehicles Act. The question which has arisen for consideration in the instant appeal is the consequence of omission of subsection 3 of section 166 of the 1988 Act. Does the above omission have the effect of allowing a claimant to file a claim application at any time, whenever he chooses, even after a decade? So, Lordship, this is a remark of the court. And Lordship, the judgment is at para 11 onwards. It has relied on a few statutes which deal with no limitation period, and also those which don't deal with limitation, which do not deal with limitation period. So in Corporation Bank versus para 11, in Corporation Bank versus Navin Shah, wherein a claim for compensation had been raised under the Consumer Protection Act, wherein also there was no period of limitation prescribed at the time when the claim was raised. Dealing with the question is hand, this court has recorded the following observations. We may notice that there is another strong reason as to why the claim by the respondent should not have been granted. The transactions took place in the year 1979 and 1981. The difficulties in realization of the amounts came from the consignee also became clear at the time when the claim was made before the corporation, and the claim has been made as early on in 1982. The petition before the commission was filed in the year 1992. That is clearly a decade after a claim has been made before the corporation. A claim could not have been filed by the respondent at this distance of time. Indeed, at the relevant time, there was no period of limitation on the Consumer Protection Act to prefer a claim before the commission. But that does not mean that the claim could be made even after an unreasonably long delay. Lordship, I am skipping a few lines in the italics portion. In those circumstances, the claim, if at all, was to be made, ought to have been made within a reasonable time thereafter. What is reasonable time? To lay a claim depends upon the facts of each case. In the legislative wisdom, 3 years period has been prescribed as a reasonable time under the Limitation Act to claim for money. We think that the period should be appropriate. We think that period should be appropriate standard. Should be the appropriate standard adopted for computing reasonable time to raise a claim in the matter of this nature. And Lordship, in para 14, drawing an analogy to the judgments rendered under the Consumer Protection Act as also on the Industrial Dispute Act, it was a submission of the learned counsel for the appellant that even though no period of limitation remains prescribed after amendment of Section 166 of the Motor Vehicles Act, wherein subsection 3 of 166 came to be deleted, yet it would be imperative to determine whether at the juncture when the claimant approached the Motor Accident Claim Tribunal, the claim was a live and surviving claim. Lordship, a few lines below, around last 6-7 lines. We are of the considered view that the claim raised before the MSCC can be considered to be genuine so long as it is live and surviving claim. We are not satisfied in accepting the declared position of law expressed in the judgments relied upon by the
You are referring to judgments dealing with the statutory provisions.
Yes, Your Lordship.
Here the rights and obligations are determined based on a NCWA, which is in the nature of a settlement under Section 18 of the Industrial Disputes Act,
yes,
which is binding on both parties. It is in the interest of the labor, a social welfare scheme. Courts have held repeatedly that you are obliged to do it from the date immediately after the death.
Your Lordship,
how these statutes can be relied upon to
I am relying
overcome.
on the point that
It is a binding nature of settlement under the Industrial
yes,
Disputes Act.
Lordship, I bow down. What I am
The
trying to
notification under 3A and binding under Section 18.
Lordship, what I am on is that
Question of
to
any
approach a court.
To approach a court is under a statute and under this are two different things.
But your
Anyway,
Lordship,
you are
they cannot-
relying on any other judgment. Yes.
Lordship, I will need to come back with a few.
No. Finish it now. There is no question of coming back. Your compilation is here. What else you
My
want to say?
compilation was with the aspect of
Whatever it is, that is the only issue pending. You know that. In all the other cases, you have paid the amounts due. Only
Lordship,
interest issue is remaining.
yes, Lordship, then I need to deal with my learned friend's judgments, which he has cited along.
You tell us how it does not apply. Tell us.
So may kindly allow me one more.
Nothing. Conclude it today. How do you get over the series of judgments which have held that it is an obligation to make a payment despite there being any application immediately the day after the demise? You are just to know of the demise, which admittedly you know because she has intimated you. And that those judgments have been affirmed by the apex court. So how you are relying upon statutory provisions, anyway, we'll consider.
Lordship, first,
So how do you get over those judgments? Tell us.
Lordship, the judgments that that they have cited
Yes.
will have their own facts and circumstances.
Yes.
So, Lordship, that I need to just go through. But your Lordship, since they are saying that the right becomes automatic upon death and they become entitled, Lordship, perhaps what the Supreme Court and the High Courts have held is that a vested right no doubt accrues, and Lordship, accordingly, we have also, if your Lordship may kindly appreciate, we have also taken a decision according to your Lordship's since your Lordship had asked us to take a decision that we.
Utul Ravidas is by a larger bench.
Yes, your Lordship.
Larger.
And there no interest was awarded in that case. Your Lordship, again, what I am on is that the judgments have held that a right does accrue upon the death. But your Lordship, it is not, probably the judges, honorable judges might not have indicated in that sense that just upon the death, I have to come knocking to your door coming with compensation. Probably, Lordship, because Lordship may kindly appreciate that we are a public sector organization and we need to go by documents, we need to go by records. There has to be a proper application, a proper claim form for anything. They have to make an application in a proper form to be able to claim compensation or whatever benefits they are claiming under the NCWA. It is not like just upon death you inform and the money will come marching to your bank account. Lordship, that I believe will be very unfair to hold, and in that manner probably the interpretation will form a bad will have a very bad consequence on the public sector organizations who need to have a documentation for everything that they do. Lordship, so far as this interest is meant, Lordship, it is purely at the discretion of the court. That is also by terms of the Interest Act. And
why you have included this judgment, Utul Ravidas? Why you have included this?
That was the parent judgment, and it talked about the entitlement. That's why, my lord, I indicated.
Lordship, for entitlement, we are paid. We are willing to
without
pay
an application.
You have asked him a question. You are not allowing him to respond.
Without an application entitlement. That's why, my lord. The rest are on this.
No, you did not place that from this judgment.
Utul Ravidas?
Yes, you did not place that relevant portion from this judgment.
My lord, I did paragraph 66, my lord. To your lordship first, my lord, kindly takes up my compilation. Some portion has been taken note of by the trial judge. Lordship said, what else? Then I pointed out, my lord, paragraph 66, last few lines, which talks about page 25.
Even no application.
Even no, yes. Not required at all. An entitlement was upheld.
And this view is apparent from any judgment of the apex court also.
Utul Ravidas?
No, this view that it is to be paid.
Yes, one Supreme Court, my lord, I have page 38, 28 to 37, next judgment.
That is not Supreme Court judgment.
But just give me a minute's time. I've indicated, maybe I missed out the relevant one, my lord. Yes, page 63 to 71. I have mentioned 63 to 71. Arekta bar koro. Justice Joseph and Lordship has got it. Page 63, the judgment starts, my lord. Page 70 is the observation. Not only employment, but also interest. Justice Kurian Joseph and Justice Santanu Gowda. Arekta bar koro. Roman 1, 2, and 3. And in other cases, my lord, the Supreme Court dismissed the SLP, which I mentioned. Within One Supreme Court, my lord, rest are the division benches, where in some cases SLP was dismissed and the Putul Robidas. This I have included in my compilation. আমার মনে হয় একটু বুঝতে অসুবিধা হয়তো। And my lord, Putul Robidas, as I said, affirmed by the Supreme Court, that lordship will find from a decision which I have annexed, that is, my lord, Sumi Kamin, page 48 to 59, Putul Robidas and its observation were quoted at page 55. In fact, my lord, paragraph 28, 29, 30 and 31 talks about Putul Robidas. Paragraph 31, page 55.
This is not of the Supreme Court.
This is High Court.
No.
This is a High Court judge.
High Court. Supreme Court, my lord, page 63 to 71. Justice Joseph and Justice Antony Gold. 63 to 71 in my compilation.
No, which paragraph of this?
Page 70. Page 70. That's Supreme Court. Paragraph 10, 11.
This is arising out of Subhadra's case.
Yes. Paragraph 11.
That is also from this court.
This one, this is from, not from this court, my lord. Not from this honorable court. I have to check.
Lordship.
That's from Bombay, Mumbai.
So that's not from this court. Yes.
Lordship, para 11 of this Supreme Court judgment says, having regard to the entire facts and circumstances of the case. So, Lordship, this judgment does not lay down any point of law. It is only for that particular facts and circumstances of that case. So, Lordship, this judgment cannot be relied upon in that sense.
Yes.
Putul Ravidas, as they are relying upon, Lordship, that judgment to that extent that I have a obligation to pay compensation from the date of death, that your Lordship, we have in principle already agreed, and that we have communicated by your Lordships to your Lordship previously. So only on the aspect of interest, my Lordship, my only argument, I am only on the judgment of the single judge, that it is on the discretion of this court, and in this instant facts and circumstances of the case, no such case has been made out for payment of interest, because there was significant delay and laches on their part.
Yes.
That is all. That is a summons. I was relying on this judgment to show that to approach a writ court and to get relief of this writ court, you must approach the writ court diligently. You must make your applications within time. Whatever applications you are making in 2016, 2024, that is.
That's all.
Not
grateful.
My lord, with my lord's kind leave, my lord, I am
Also
appearing
appearing
on
in
behalf
this
of.
case.
Yes, my lord, it is item number 2. I am appearing for the respondent, and item number 9, I am the appellant, my lord.
Item number 2 is with this case.
No.
My lord, the order
Connected,
has
all
passed.
connected, but I am in 1 and 8.
My lord, item number
Just a
2.
minute, just a minute, just a minute. This you are
my-
appearing in the case of Mayapuri.
No, my lord, I am
Then
appearing in
please
the
wait.
case of
Yes,
Mukhi Mejai.
please wait, please wait. Yes.
Lordship, the
All
other
right.
judgment that
Right.
has relied upon SK Dua versus State of Haryana. My learned senior counsel has relied upon this SK Dua versus this one, para 14. This is again not related to NCWA. This relates to some, and it states that if there are administrative instructions, guidelines, or norms prescribed for the purpose, the appellant may claim benefit of interest on that basis. But so this is not on the aspect of NCWA.
We'll pass the order tomorrow. Third, the parties. List for orders tomorrow.
My lord, only one indulgence, my lord.
Next, call the next.
My lord,
Call the next.
We have paid for interest of 18%, but if the quotes are with me, my lord, I read it to your lordship.
See,
Yes,
regarding quantum, we will see.
no, absolutely is the discretion of the court. I must point out, my lord. I'm
If,
grateful, my lord.
I'm just saying that this, whatever, if your lordship feels that this should be awarded, or if your lordship does not feel it's to be awarded, that's a different thing. But your lordship may also kindly consider our conduct in awarding, in agreeing in principle to pay them from the date of death. That may also be kindly taken into consideration.
Very well.
Grateful.
Yes. Call the next. One by one.
Back of the ball. You just got to think.
No, this argument is only in Maya body. This is argument from 1 to 9. No, we have considered only one case.
One
Maya body.
and cross appeal. Cross objection.
Cross
1 and
appeal
8.
is at 8.
1 and 8.
1 and 8.
Absolutely.
2.
Well,
Who is appearing in item number 2?
Well, 2, I'm appearing for the respondent, and there is an appeal filed by on behalf of the company. It is item number 9. I am the appellant.
Regarding interest, the order passed, my lord, absolutely in light of my lord, the Maya Bauri judgment.
My lord, unfortunately, that is not my primary grievance, my lord. My lord, in my appeal, item number 9, I have prayed
Cannot
for.
argue item number 9 before 2, madam.
My lord,
Yes.
it is the cross appeal, item number 2.
You have filed the main appeal.
Yes, my lord. Appeal was
Alright.
filed by me and cross appeal filed thereafter.
My lord, appeal against the order.
My lord,
What has been directed by this?
Kindly see page
my
20.
lord,
Page?
Page 21 of the my lord, memo of appeal. Sorry. I'm sorry, my lord. The page number.
So it is in the same terms.
Same.
Order is passed in the same terms.
Because of if the Maya Bauri
Date would be different. What is the date of demise?
date is my lord here. Date is demise on my lord October 10,
October 10.
2012.
Yes, my lord.
October 10.
October
10, 2012, my lord.
10/10/2012.
Yes, my lord.
And
My
what,
lord.
according to you, there is a belated application.
No, my lord. The facts are different in this case, my lord. That is
Yes.
my grievance. It
Please
has not
tell
been
us.
noted. It has
Please
not
tell
been noted in the solemn order and judgment, my
Very
lord.
well, very well. So tell us.
My lord, the primary grievance is, my lord, the matter came up for hearing on the day, and I was actually praying for coming back with instructions. And my lord, this is my humble submission. I believe that order has been passed hurriedly in light of Maya Bauri. My lord, here the case is different. Maya Bauri, they applied for employment of this case. Maya Bauri, there is no contradiction in regards to the service period of the ex-employee. But in this petition, it will reflect from the writ petition that there was unauthorized absence, my lord. It is not the same case as Maya Bauri. My lord, writ petition shall reflect the same, my lord. I shall refer to that. My lord, may I refer to my appeal, page number for 65.
Yes.
Item number 9, it is. My lord, this document they have been relying upon. This is the document which has been disputed by me in the trial before the honorable trial court, my lord, that they had submitted any application or something praying for that in the year 2024, which I have disputed because there is no seal, there is no receipt, no acknowledgement, nothing. My lord, it is appearing at page 65 of my appeal.
It's not 24, it is 14.
Yes, my lord, it is 14.
Not
It
20.
is 14, yes. And thereafter, my lord, on the next page, page 66, where the writ petition, the ex-employee himself is narrating the facts that he was not present since 2005. He was not there in duty, or he was not a regular employee. He was not there. There was unauthorized absence. All these facts are losing. There are no recordal of that. And I prayed for one accommodation that I can submit a report and all these facts can be brought before the Honorable Court. My Lord, this has not been considered. My Lord, may I read out? Page 66 of my appeal. My Lord, here, with due respect and humble submission, I beg to state that I am permanent employee of your colliery, white so-and-so, designation so-and-so. I like to inform you that I am suffering from TB disease since long time, and I was under treatment of doctor of our colliery dispensary and central hospital so-and-so. The said both doctors properly examined and diagnosis and granted TB Khoraki. And besides, prescribed medicines continue till recover. But the authority given TB Khoraki only 5 months and the said dispensary closed. In my condition, this time declared me not available medicine. At the time, my serious position at night, I quickly informed my friend. He took me to our family doctor, MK Pandey, doctor so-and-so. Condition immediately, diagnosis and declared me TB disease on 14/12/2005. And under treatment from 14/12/25 to 28/11/2006. Lastly, he declared me fit to join my duty. That is a private doctor, not the coal company's hospital or anybody. After my recovery, I was coming to report to same dispensary and office of personal manager so-and-so with submitting all the medical papers. Those period. Further, like to inform that I have several times attend your controlling office but not response to join duty matter, and already been year past. At the time, my miserable condition could not purchase food, diet, and maintain my family. Besides studies of school of my children, this time I bound to do daily labor. So he is acknowledging he joined somewhere else. He joined somewhere else. Labor work of building constructions at Dhaka. Unfortunately, one day of work time, sudden my injury of back position on 11th of May 2008. I was quickly hearing my family members. They are took to our family doctor MK Pandey, the same doctor he referred for TB, and near the working place. It was under treatment from 11/5/2008 to 29/9/2009, and the said doctor advised me to take full rest till recovery. Lastly, on 30/9/2009, fit to join in my duty. Recently, I am suffering from serious disease, hydrosis infection. I have been admitted in Central Office, Calcutta. Kalla, I am only earning member of the family, and it is my lord. So on, he was not in service. This shows these documents. I am reading from the writ petition annexure. So this is not the same case as Maya Bauri. Even though Maya Bauri has been referred in this matter, my lord, these documents and everything, whether he was at all eligible for claiming anything, my lord, that needs to be considered.
Yes.
It was not heard, my lord. Subject to correction, this is my humble submission.
That is why we are hearing you. That is why we are
Yes,
hearing.
my lord.
Now you
My
have
lord.
placed all the documents. Yes.
I'm obliged, my lord.
Yes.
My lord, that is the reason. This is my main grievance, my lord. Apart from and there comes the point. If the employee was not a regular worker when he died in harness case, then how come his dependents are coming before and praying for these
His claim
entitlements
was
and
rejected.
benefits?
Did you reject his claim?
No, my lord. The annexures, the representations they are referring to 2024. So I'm sorry, my lord. 2014.
14, yes.
I have disputed that because there is no acknowledgement, seal, anything. My lord, as per my instructions, they have never received this. And 2025, they have filed an representation. 12 days after sending that representation, they have filed this writ petition, my lord. 12 days. The authority was not even granted a reasonable time to respond to the representation. They could have waited for a regrettal or whatever reasoned order is being passed, and thereafter they should have approached the Honorable Court, my lord. That is my humble submission. Whether interest should be given, whether arrears should be given, that comes later.
According to you, she is not even eligible for MMCC.
Yes, my lord, because these facts needs to be considered. They should have given time
Where you have
for
stated this?
consideration.
Where is this stated in your appeal?
In my appeal also, I have referred to, my lord.
You have filed an opposition.
No, my lord, nothing has been filed by the. Till date, my lord, this matter didn't came
File
up
it.
for hearing because
They are
Maya Bawri was
disputing
being.
your claim altogether. It's not a question confined to interest. So
So
if you
kindly-
have the option of filing an opposition or proceeding as it is.
But kindly see page 72 of the order. They have himself appear. They never objected before this court.
No, no, no.
Again,
My
we are
lord,
telling you, you have the option of filing an opposition or proceeding as it is. Tell us.
Or I shall file opposition.
Then don't make submissions. Yes. The learned advocate for the appellant.
my lord, I cannot hear the order. It is being muted.
Yes.
My lord, only one indulgence, my lord.
Call item 50. Call item.
My lord, I could not hear the order. It was paused.
Mute. Please mute. Yes. Yes. Call them. Item 50.
Item number 2 p.m. fix for the lordship. Item number 2.
Yes. Those matters which have not been called, why are you mentioning, sir? They will go to another date. Yes. Any state council is there?
Alam Chandrai Alam and Malad, on Bhumi Mukherjee appeared, I've served them copy, Malad, in terms of lordship.
We'll record your submission. It is the learned advocate for the writ petitioner